Requisition for calling affidavit file yesterday.
So in item number 1, in item number 1, we are also filing an affidavit. In item 1, we are filing an affidavit. I will be allowed to call for it.
Item number 1, you file affidavit.
We are filing it. We have extra copy.
Top of the list, item 1. Yes.
Sir,
What is your stand?
my lord, my instruction as communicated to me yesterday evening, my lord. The plot of land was surveyed, my lord. It was not demarcated, my lord. It was not demarcated. On the basis of the survey, they have stated that the land is inside the campus of the FSD Changsari, my lord. They have in fact not demarcated, and we are willing to retain the land if it is demarcated, my lord. If necessary, I can file it on affidavit, my lord.
You are willing to demarcate the land, I mean, if you are willing to retain the land means how?
Subject to your lordship order.
How?
And since your by
No,
last
the
order,
offer was
your
already
lordship has-
given, offer was already given by the state to go for an outright purchase. How? Are you going to ask the
by
state to
your
requisition?
lordship last order, my lord, your lordship has stated that whether we FCI is willing to retain the land or not. We are willing to retain the land.
How?
Yes.
That's the next question, how? Because they say that they have made the demarcation which was made earlier was wrong, because they said about 1 kata 17 lessons, which is wrong. But subsequently, I've asked them to do something. They filed an affidavit.
We have filed the affidavit. The last one of paragraph 10, lordship has directed us to indicate 3 issues. Kindly come to the last order. Paragraph 10. The direction is given to my learned friend at para 9 and to us at para 10. Lordship has said that they shall apprise the honorable court as to what will be the amount now payable to the petitioner in respect of 7 lectures of land in view of the interest as statutorily mandated and as to when the said amount would be paid to the petitioner. The learned so and so shall also seek instruction as to who were responsible, which led to the non-tendering of the amount of rupees 54,670 to the petitioner. But this we have filed the affidavit.
Then again at paragraph 11, so and so learned counsel appearing on behalf of the respondent number 4 and 5 shall apprise the court on the next date as to whether the respondent number 4 and 5 would like to retain the possession of the 1 kata 10 lectures. Our humble submission is that on 16/8/2024, there was a survey made by the department, my lord, revenue department, Lord Mandal team, we were also there. But they just surveyed the land, and because the land was submerged in water, so they state to us that it will be demarcated later on by the Assam Land and Revenue Authority, my lord. So this instruction that I have received through my email last evening, my lord. In fact, it has not been demarcated, my lord.
So are you saying that the circle officer has given a wrong statement by way of a document enclosed to the affidavit?
Yes, my lord. Their annexure page 32, my lord. They said as per field verification on 16/8/2024, it was found that the land measuring so and so covered by so and so belonging to village Changsari falls within the boundary of the FCI Changsari. It falls within the boundary of the FCI Changsari, but it has to be demarcated also.
No, I'm not concerned. Question is whether it falls within the ambit of it. It falls within it. Where it is, I'm not bothered. But is it within the campus? Are you denying to that it is not
within the campus? Demarcation.
I'm not concerned. You have a campus with boundaries.
Your lordship itself has stated in the last order that it has to be demarcated, my lord.
I have said,
Yes,
because now 1 kata 10 lectures is to be there. Because 7 lecture is out.
As per their survey, it is inside the boundary, my lord.
So that is the only thing which they have stated, that it is within the boundary. Now, Mr. Nath, tell me why will the FCI pay you this 93,000?
But
Fault is whose? FCI has already given you 59,000.
that is correct, but
Why will FCI pay?
well, ultimately the land
Isn't
is,
it hand twisting the FCI?
land is with them, Lord. They are
Understood.
utilizing.
They have already paid. In 2011 or 12, they have already paid that 59,000. Then why will the FCI pay? You're not concerned how you arm twist the FCI, how you get it, it is your lookout. But the fact that he has to get the money is the question which I am there.
That,
I only gave you a handle
that I
to
have,
find out as to whether there was tendering of the amount of 59,000 to the petitioner. Because once it is tendered, then the burden of payment of interest does not arise. I gave you only that handle in my last one. Now, there is nothing on record to show that it was tendered.
well, in fact, logic. As on today, there is none. And Malad, we said that in our affidavit, we have said that logic also indicated that why it was not tendered and or who is responsible for not tendering that. But to that, Malad, we have in fact wait for some time. It is the process is going on, Malad. We'll see that.
Now, that is another thing.
Logic.
Now,
Otherwise-
why,
otherwise
no,
it's
why
definitely-
what you are doing is you want to take the money from FCI. You are a government entity, they are a government entity, whatever, both of you may have an understanding, it's a different thing. It is outside the scope now. But the question is the petitioner has to get this 1,47,000 which is there for the 7 lessons he will get. Now, what about the remaining land?
Remaining land, Malad, logic has directed them whether they want to retain or not. If they don't want, Malad, then we have to demarcate. They said that
We are willing to retain that land.
So you are waiting to retain the land, then how? Because that is relevant, why I'm saying so. If you are willing to retain the land, it has to be on the basis of something. Either you do it by them or them. Because if you are going for an outright purchase, there is another aspect.
that logic. Otherwise,
Then it will may have a lot of other permutations and combinations. And if you are not going, you are asking them to acquire the land for you. They will have to acquire it as per the present market value. This 1 kata 10 lectures.
that way.
It can't be on the basis of that time.
Yes, sir. That is also one of the consideration whether,
Huh?
that is also one of the matter to be decided whether it will be at the present value or the value that was in 2012, my lord.
Why? Why 2012?
Because in 2001, we have written letter to the government, right, Annexure E, my lord, that kindly do the needful. If it is inside our will.
You ask, you claim from the government whatever amount is, that is a different thing. Government did not do. We are not concerned with the government about that. They only did 7 lessons of land and you knew it. Only 7 lessons was there because you had that document with you.
Yes.
And his land was 1 kata 17 lectures in 247. So therefore you knew at that point of time. They did not do it. That is your lookout. Either you give him the land. Then I can ask them to demarcate that 1 kata 10 lectures and take it out and give it to him. But if you retain it, I don't pass that order. 7 days.
Obviously,
I'm
we
asking.
wanted to retain it, my lord. Obviously, we wanted to retain it. Now, your lordship, next question is whether it has to be at the present rate, my lord. Your lordship, next question is that it has to be at the present rate, not the rate at in the year.
Absolutely. It is a new acquisition that you are in possession of the land illegally and therefore you would be now
We are
thinking
not-
about that,
we-
okay,
we
I'll
are not
purchase
in
at that
possession
rate.
illegally, my lord. Whatever they have acquired land for us, whatever they have handed over, we have taken. And we have paid the, as per the amount asked by the
Mr.
government.
Singh, there is a very beautiful judgment of Justice Dalbir Bhandari. A question arose once as to whether the state can have adverse possession over the properties of the private individuals. That I am there for such a long time, it is under my possession, can it be there? Supreme Court categorically said that the state cannot have an adverse possession. The possession, if it is there, it is an illegal possession. The concept of having any prescriptive right over the state is not there because it is always presumed that the state would not harm the private individual.
Yes.
Then, so your possession is illegal.
But here in this case, already in earlier orders, Lordship has also reflected that from this, the deputy commissioner, some communication has been sent to them that you
That is there.
offer is
That
there,
is why I'm
purchase.
saying.
offer is there purchase.
The state deputy commissioner asks them to go for an outright purchase.
Purchase.
My lord, we
And
have.
They say that no, we are,
Second-
they say that where is the question of outright purchase? All this land has been given to us.
As per
No, my lord,
acquisition.
we have stated, right, annexure E, we have stated that since we are also a submitted by the due to, and accordingly land here or for acquisition were handed over by the deputy commissioner, MD of up to, as such, it is kindly requested to look into the matter so that the matter be resolved by the state government. We have given him there to kindly resolve the matter.
So?
But since we cannot outright purchase from a
Why?
individual, my lord.
If you are now purchasing him outrightly, it will be cheaper if I am not wrong. Because he will go as per the market value. And as per this, it will be,
My lord,
the multiplication factor will be
So
applied.
my lord
to-
has, since my lord has given me the option, my lord, can it be taken up on next Friday? I will take instructions regarding outright purchase on the basis of that document, my lord, that has been offered by the government, my lord.
We fix it on 23rd of September. In the meantime, pay this 1,47,000. How you recovered from them, that is your look. You said in your affidavit that 1 month. But I am having it on 24th of September, pay by 23rd. That is enough. 23 days is enough. Pay that 1,47,000. I don't want the further accruing of the interest on that. And you come up with your affidavit. What to do? Else we are asking them. During Puja holidays, he should otherwise enjoy their 1 kata 10 years.
We will take into consideration the earlier offer that was made by the government, my lord.
Not concerned about
And
all
since
this.
your lordship has given me the option.
I
can
am
go for it.
not anything to
My
that
lord,
effect.
my
You do whatever you like, but I will record a statement that you are going to retain.
Yes, yes, I have the document, they have.
You have no problem with the demarcation. There's no problem
We
with that.
have a problem with demarcation.
No, no,
They have- they
I'm not
have given-
concerned about whether. Only question is whether his land is inside your boundary. You have no, there is no denial to the effect.
My lord, since the government has acquired the particular land, my lord, and it has been handed over to it, and thereafter we have given the, my lord, the compensation to the government, my lord. So my say is that, my lord, whether that entire land, after measuring the entire land, whether it will be, whether there is any enough land, then only it will be decided that, yes, his land is also inside my land. Demarcation, my.
They have already demarcated and found out on 16/8 that this is, his land is inside yours.
They have not demarcated.
Okay, then I'll direct them to demarcate and throw you out.
Yes, madam.
Uh,
No, not.
No. It cannot be like this. To throw you out within 7 days. You demarcate and throw them.
Made order.
I'm having it next Friday for them.
So
You
since,
demarcate and
my
throw them.
lord, that option may be kept open.
No
on
option.
23rd,
There is
my
no option out there. Either you have to accept 16/8 or I'm directing a fresh demarcation because the demarcation can't keep on going. There is a categorical statement made that 1 kata 17 lectures, which is in dark number 247, is inside your boundary. In your presence. So under such circumstances, you either deny or accept. You deny, very well, take it over. Let them do it. It is outside, you take that risk. You can't have so much of options. It's an illegally retained land. And apart from that, you also have to pay for this 1 lakh, 1 kata 10 lecture amount to him. Mean profit, who is going to pay? For these 11 years, who is going to pay them? Every month, how much? 5,000?
Yes. Yes.
Something you have to pay. You have been there for how many years? 11 years you are in illegal possession of his land. The state cannot do that. You have to pay that.
So, my lord, I will go
FCI is
for-
very big,
So, my
central
lord, I will
government.
go for the earlier option that lordship has given, that to matter will be taken up on 23rd, and then we will, I will convey by through the affidavit that we are going through outright purchase or through land acquisition.
Better. Otherwise, paid it. Let us close it from there. Pursuant to the order passed by this court on 22/8/2024, the District Commissioner, Kamrup Amingao, had filed an affidavit stating inter alia that it could not be found out as to who were the officers responsible for not tendering the amount of rupees 54,670 to the petitioner. However, the inquiry is still on. Be that as it may, it has been mentioned that in terms with the applying the interest in terms with Section 34 of the Land Acquisition Act 1894, the total interest, the total amount along with the interest would be rupees 1,47,795.92. That is rupees 54,670, the original compensation, and rupees 93,125.92, which is the interest. It has also been mentioned in the said affidavit that the amount of 1,47,795.92 can be disbursed to the petitioner within 1 month. In addition to that, it has been mentioned that the FCI would be roped in for the payment of the interest. This court have also inquired with the learned counsel appearing on behalf of the respondent number 4 and 5 on 22/8/2020 by order dated 22/8/2024 as to whether the respondent number 4 and 5 would like to retain the possession of the land of 1 Katha 10 Lecha. Mr. B.K. Singh, the learned counsel appearing on behalf of the respondent number 4 and 5, submits that the said respondents is ready to retain the said land. However, the modality in which the said land would be retained would require certain discussions to be carried out with the district administration as well as the higher ups of the respondent number 4 and 5. And as such, he submitted that some time would be required. This court accordingly fixes the instant writ petition again on 24th of September 2024. In the meantime, the district administration of Kamrup Rural is directed to disburse the amount of rupees 1,47,795.92 to the petitioner. This court further directs the petitioner to submit the bank details along with a certified copy of the instant order to the office of the district commissioner, Kamrup Amingao, by 2nd of September 2024. This court is not commenting anything on the as to how the district administration would, as to whether the district administration can request the the respondent number 4 and 5 in respect to the amount of rupees 93,125.92, it shall be absolutely within the domain of the respondent authorities along with the respondent numbers 4 and 5. Full stop. Further to that, this court directs the respondent number 4 and 5 to file an affidavit on the next day on or by 23rd of September 2024. In what modality the respondent number 4 and 5 would like to retain the land of the petitioner measuring 1 kata 10 lecha covered by dag number 200 and dag number 1693 of KP Patta number 331 of village Sangsari Moza Sila Senduri Gopa, which is in the possession of the respondent numbers 4 and 5. List accordingly.
Only one objection is that how we are responsible for giving interest of 93,000.
That is what I said. I am
We
not
have to already
commenting.
pay. We have to already paid for that 10 lakhs.
Mr. Singh, that is what I put the question to
Yes,
him.
madam.
That is why he said the district administration says that we are going to, we are asking you to pay. Therefore, I said that I am not commenting. It's absolutely lies within the wisdom of them with you.
But only one thing, it typically comes to page 50 of the affidavit filed today. But there, as per our record, name of Pattadar is shown as the original Pattadars from whom the petitioner has purchased the land. So some land documents may be required, so.
There's no denial to the effect because there are many, finally don't bring that issue because all along you have been stating that it is the petitioner's land. Then how are you raising that issue? Don't.
Those are required, she will submit. Only indicating that.
Because everywhere, in fact, you have paid, you have already paid some other compensation earlier. For 3 bighas of land, some compensation has been paid.
Always. Okay.
Supplementary item 21 top of the list.
এই বাকি কিটা আৰু কেইটামান আছে আৰু কেইটামান দিব আৰু লিষ্টখন ক'ত
My lord,
all this where is this 21 to 26
You are not sick, you have to,
all these are same matters.
you have to file undertakings for sick.
Okay.
I have called my petitioner today, but my lord, actually the land belongs to this and other cases are not the same area. My lord. The proposed project, they are saying the proposed project. The proposal is going on another area, my lord. It is
I'm not on that.
Not Jalukbari.
No, the land, the finding of the court below is specific to the effect that this is a
It's railway land.
railway matter over there.
But
This
my lord,
court cannot make the real Public Premises Act an useless matter there ends.
they are residing since long, my lord.
Huh?
They are residing there since long. Till
Can't
that the
help
railway
it.
is,
Can't
railway is
help
not
it.
going to.
Can't help it. If you are in
No,
railway
sir.
land here, because you see, after all, these are public premises.
The petitioners is that we are going to evict 21 families also.
Huh?
Not only petitioners also,
Yeah.
21 families also.
Anyways, we take all these matters at 2 o'clock. Are you going to file that undertaking or not? If you are not filing, then I take up this matter, I dismiss your matter and I take up these matters.
22, 26 we have filed. They have filed also.
So, under such circumstances, I take up his, give him 3 months. You are not willing, I dismiss your petition. Then you go to the revision bench.
May matter. I have taken issue. They are saying that in that area, not project is going on. So
I'm not concerned with the project, the fact that it is a railway line.
dismissed. May dismiss them.
Huh?
May dismiss my lord. May dismiss my lord on merit.
Yeah, petition line.
Second fill do. Second fill do. Oh. Second
এই
fill.
পাঁচটা মই এয়া কৰিছো, হা?
21 or second fill? 21 or second fill to do.
A 21 of a
22 and 22 to 26 are different. Madam.
There I'm passing that order,
They
giving you
didn't file.
3 months.
Yesterday I have received those.
And it's okay, but this I'm dismissing
Yes, sir.
after this. First, let me pass these orders in these.
Yes.
Undertaking. Where is the undertaking?
My lord, we can send while it is coming.
এটা দিছো বাকিটা সবতে হবে।
Rita Roy, Rita Roy.
Yes, what is this government land you are mentioning again in the affidavit? It's not government land, it's railway land. Your entire edifice is, it is government land.
My railway line, we are not,
Oh, that is the most important thing.
my lord, because
It becomes very easier later on after 3 months.
proceeding, my lord, we have said that it is not a railway line, so
The entire proceedings you have stated it to be a government land.
without any condition, my lord, we are deprecating.
Understood, but why you are mentioning it? I'll hand over the vacant possession of the government land. That is your entire case. How do you strike down?
The hastily it is filed, my lord, that is right, because we have to file it very hastily, my lord.
But the
Anyway, my lord,
entire
we are-
basis of the case was railway land.
My lord, we are not meaning it any manner, my lord.
Huh?
We are living, we are ready, my lord.
Okay. Heard Mr. T.H. Hazarika, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned counsel appearing on behalf of the Union of India. This court, by an order dated 29/8/2024, observed that the judgment dated, the judgment dated 31/7/2014, 24, 14 passed in Miss Appeal number 7/2024. No, 2024. Passed by the Additional District and Session Judge number 1, Kamrup Metro at Guwahati. Requires no interference, taking into account that the findings arrived at is based upon proper appreciation of evidence. This court further, upon perusal of the judgment dated, this court further full stop. At this stage, it is next. At this stage, it is relevant to take note of that the dispute between the petitioner as well as the railway authorities in the proceedings under the Public Premises Eviction of Unauthorized Occupants Act 1971 was solely on the question that the land in question wherein the petitioner was in possession was a government land, government wasteland, and not railway land. Full stop. The estate officer of the railway, of the Northeast Frontier Railways, in eviction case number EO oblique MLG oblique 19 oblique 2023, came to an opinion on the basis of the evidence on record that the land in question is a railway land. প্রত্যেকটাৰে কেছটো বেলেগ হ'ব paragraph 1 সেই কেছ নম্বৰটো আছে দেই এই eviction কেছ নম্বৰটো being aggrieved, the petitioner assailed the said order passed by the estate officer in misappeal number 7 oblique 2024. This court have perused the judgment dated 31/7/2024. Finds it relevant to take note of the point of determination number 1. Finds it relevant to take note of the findings arrived in point of determination number 1. In the impugned judgment. The learned court, First Appellate Court, after taking into account the materials on record and including the evidence so tendered by the circle officer of the which revenue circle? Of the Guwahati Revenue Circle, had come to an opinion that the land in question is a railway land and not government land. And on the basis thereof, had further come to a finding that the said land would come within the ambit of Section 2E of the Public Premises Eviction of Unauthorized Occupants Act 1971. This court have also taken note of the adjudication so carried out by the learned First Appellate Court in respect to the other 3 points for determination, and is of the opinion that the same is in conformity with the provisions of law. This court further, at this stage, this court finds it very relevant to take note of that when the instant writ petition was entertained on 29/8/2024, this court, having prima facie opined that there was no illegality in the judgment dated 31/7/2024, passed in misappeal number 7/2024, gave a liberty to the petitioners to submit an undertaking if they sought for some reasonable time to vacate the land in question. Accordingly, the petitioner has filed an undertaking in the form of an additional affidavit on 30/8/2024. Stating inter alia that the petitioner shall vacate and hand over the vacant possession of the land being the subject matter of the instant writ petition to the concerned authorities within a reasonable time on or before the expiry of 3 months from the date of the order dated 29/8/2024 or as directed by this court. Paragraph 2 of the said undertaking being relevant is reproduced hereunder. This court, during the course of the hearing, inquired with the learned counsel appearing on behalf of the petitioner as to why in the undertaking there is a mention of the government land. The learned counsel submitted that it was inadvertently mentioned as government land. It should have been mentioned as the railway land. And on account of the requirement of filing of the said undertaking in a short span of time, this inadvertent error had crept in. Be that as it may, the learned counsel appearing on behalf of the petitioner submitted that the word government land mentioned in paragraph number 2 of the said affidavit undertaking should be construed as railway land. Taking into account the above, this court have also heard Mr. K. Gogoi, the learned counsel, appearing on behalf of the railway authorities. He submitted that what infrastructure?
That particular land, we exchange with the STC Lossi. That particular land Lossi, we have exchange with the STC in the Palton Bazar Lossi. The Palton Bazar STC land, we are going to construct world class entry point, second entry point of the railway Lossi. And in that particular place, they will construct the Lossi STC bus stand. It will shift it from Palton Bazar to that place Lossi.
That place.
That place. Already demarcation was already carried out Lossi. 20 because we have handed over to the STC Lossi.
Submitted that the same is required for infrastructure projects. And already demarcation has been carried out. This court, taking into account the above undertaking and the fact that the petitioners have all along been in possession, and it would be difficult on the part of the petitioners immediately to difficult on the part of the petitioner to choose to get alternative place for dwelling in such a short span of time. Observes and is of the opinion that some time is required to be given to the petitioners for vacating the land in question. Accordingly, this court, while affirming the judgment without interfering with the judgment dated 31/7/2024 passed in Miss Appeal number so and so, grants 3 months time from today to the petitioners to vacate the land in question and hand over the possession to the railway authorities. Full stop. In other words, the petitioner have to vacate the land by 30th of November 2024. Full stop. With the above, the instant petition stands disposed.
Applied.
Now his matter.
And also in respect to other matters, only judgment date will be changed also.
Judgment date and undertaking will be different, huh? Yes, what is your argument? Tell me. Look at this.
I was served notice on 2016, my lord.
Huh?
After that, I have gonna appeal. Originally, I was first notice was served in 2016, my lord.
Uh,
And after that, now 2024, the appeal is dismissed, my lord.
Mm.
I have not, I am admit that this is railway land, but I am saying that this is a large area. There are more or less than 500 people here in that area. But in that area, particularly, only me.
Mm.
Want to
Let's see
have-
your reply. What is your reply to the notice which was given? What is your stand?
Actually, in reply, I am saying that it was Sarkari land.
Illegible dates mentioned in the impugned order and the stamp and he could not under
It's not party, ma'am.
by the order the prayer of the area was allowed by the area. To repeat the public premises in the initial few of the
Take paragraph 21 and 22 of the revenue.
Which are your houses? Annexure H.
Houses that are asked, when
Huh?
where the water tank is there,
Water tanky
in
is
the
there.
first photograph,
And what about the other houses?
all the area, man. All the area,
Hmm?
all Jayamati Nagar area.
And what is there on page 64?
Basically, a road
Hmm?
road inside the area, madam.
Road?
That area belongs to railways.
And what has happened, Mr. Gogoi, what has happened as regards the other 21 persons?
21 family we will evict, lot. Same procedure.
They have been evicted.
No, lot, we will evict, lot. We will evict, lot. It is in process, lot. Yeah, adjacent to the railways. lot.
So what is your case?
My lord, if for railway project, they need the land, I will vacate, my lord. But till then, allow me to stay there. Because at that time.
You have
on-
already made the project which was
that time,
initiated. No, first of all, it cannot be that they will have a project. They started having a project in the year 2014 when they issued notice to you. You have been successful in dragging this matter from 2015 onwards till 2024 before the first appellate authority. Isn't it?
But at that time, only I was.
You
issued
have
notice,
been in good
not
grace.
other persons.
Huh?
At
That
that time,
can't be
only
the
I was
reason.
only issued notice.
You have to show that this is a government land. You have not been shown anything. You could not show that it is a. You have filed your application for settlement after the eviction notice has been issued. Show me one document to the effect that this is a government land. Nothing. How do you take care of that? I would have taken that. If you can show me one document, I'll have it on next Monday. If you can show me one document that is a government. Because you see, the difference in these matters with that matters is that that court had duly taken into account the evidence of the circle officer. And all these things have been duly, which has not been done here. Here it has gone on the question that you have not produced any document to show. The railways have shown all documents that this is the railway.
Yes, my lord. That is right.
Merely filing an application, you have been able to remain. I think by tomorrow you need to vacate. Sunday is a good day.
Lordship, even Lordship, for JCBs are from
Yeah,
Lordship
we should not.
Thursday, as per Lordship's direction, we are
Sunday.
stop Lordship.
Sunday you vacate. Okay, let me tell you this. Heard Mr. G. Pathak, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned counsel appearing on behalf of the railway authorities. The instant writ petition is filed challenging the eviction proceedings initiated against the petitioner under the Public Premises Act 1971, for short, the Act of 1971, as well as the judgment passed by the judgment dated 19/6/2024, passed in Miss Appeal number 4/2016 by the Court of the Additional District Judge FTC number 3, Kamrup Metro at Guwahati. From the perusal of the materials on record, it is seen that the estate officer of the NF Railway had issued 2 notices to Dulal Roy. Why Dulal Roy is not before this court?
Actually, all the electricity connections and municipality were in the name of Ritaroy. And in the appeal was filed by Ritaroy, and it was allowed by the
Tara is the wife of Dulal.
wife of Dulal.
Okay. Were issued to Sri Dulal Chandra Roy, who is the husband of the petitioner. No, issued notice under Section 4 of the Act of 1971 to Sri Dulal Chandra Roy, who is the husband of the petitioner. Both the notices were in respect to different plots. In eviction case number EO/MLG/4514/2015, the land in question was plot number 1,2 bracket cat -1 CAT cat -1. And in eviction case number EO/MLG/4515/2015, the plot numbers were the land was plot numbers 3, 4, and 5 bracket cat -1. To the said notices, the husband of the petitioner duly submitted replies. Pursuant thereto, pursuant to the said reply, an examination of the documents by 2 separate orders, both dated 9/2/2016, in both eviction cases, the estate officer directed the husband of the petitioner to vacate the land in question. Being aggrieved by the said order, the petitioner herein, who is the wife of the said Sri Dulal Chandra Roy, filed an appeal, being Miss Appeal number 4/2016, challenging both the orders of eviction in eviction. In the said appeal, the petitioner as appellant grounds pertain to that the land is a government cast land and not the railway land. And in that regard, she has applied for settlement of the said plot of land before the District Revenue Authority of the Government of Assam. It was further the case of the petitioner is that the petitioner have been residing in the said plots of land since 1980 by constructing dwelling houses, and the houses have been given a municipal holding and along holding by the GMC authorities. In addition to that, the petitioners also have an electricity connection provided by the APDCL authorities. The petitioner further assailed the order of eviction by the estate officer on the ground of the principles of natural justice. The railway authorities challenged the maintainability of the said appeal on two grounds. Namely, and two grounds, that is, first, that Dulal Chandra Roy did not assail the orders of eviction and as such had attained finality. And secondly, filing of one single appeal against two separate orders of eviction in two separate proceedings. It is seen from the judgment passed by the learned First Appellate Court dated 19/6/2024 that the learned court did not find merit in both the questions as regards the maintainability of the appeal. And as such, decided the said appeal on merits. This court have also perused Full stop, merits. On merits, the learned First Appellate Court came to a finding that the eviction, that the orders passed by the estate officer dated 9/2/2016 in both the eviction proceedings were in accordance with law and did not require any interference, and accordingly dismissed the appeal on merits. Being agreed, the present writ petition has been filed. This court, while entertaining the writ petition yesterday on 30/8/2024, and finding prima facie there being no illegality in the impugned order, provided an opportunity to the petitioner to file an undertaking if they wanted some reasonable time to vacate, and accordingly fix the matter today. The learned counsel appearing on behalf of the petitioner submitted that the petitioner is not inclined to submit any undertaking, and as such submitted that the matter be decided on its own merits. Taking into account the above, let this court therefore take note of the respective submission of the learned of the parties. The learned counsel appearing on behalf of the petitioner submitted that the respondent railway authorities have singled out the petitioner, and there are many other houses wherein no such steps have been taken. Under such circumstances, as the respondent authorities have taken such an action arbitrarily to only evict the petitioner, the impugned eviction proceedings is required to be set aside. What other ground?
Yes, my lord,
Anything more?
nothing, nothing.
Tell me.
I'm
Give
saying that
me, tell
if
me
there is-
just, I will.
If there is going the process, we must vacate. We must vacate. If other person, he is saying that another 21 persons have been sent notice. But as per my information, no such notice has been received by their neighbors.
Okay. Now that I will record, don't worry that. But any other ground, give something good. Otherwise, you are saying that I'm going to fight on merits, but you are not doing it. This is not a merit question. No, give something, give me some good ground.
Yes, in appeal it is proved that it is a railway land, my lord. I know it. But my question is why only in that area only was issued the order.
Yes, sir. He further submitted that this is not a case where the railway requires the land. For any infrastructure project. If there was any infrastructure project, the petitioner would have no objection in vacating the land. However, there being nothing but only singling out the petitioner for vested reasons. Any more? On the other hand, Mr. K. Gogoi, learned counsel appearing on behalf of the petitioner, submitted that not only the petitioner, there are 21 other families, other houses, which are required to be evicted. And in that regard, the process have already been initiated. He submitted that on 30/8/2024, the railway authorities have already initiated the process. However, in view of the order passed by this court, the same was stalled. Eviction, why infrastructure? What infrastructure?
Development project, they have just instructed me, it's a development project.
What development?
So see, the expansion of the railway that line.
Huh?
Expansion of the railway stations that area loss.
Railway station. Where is this land?
It is
My
adjacent to
lord-
the Joymoti Nagar area loss.
Joymoti Nagar in not in a railway station area, my lord. That's opposite in a Pandu area.
That losses Pandu, when losses go to the Pandu area losses, then one extension, railway extension losses will seen losses. That area we are going to develop losses. That good stands are losses. Earlier there are good stands are there losses.
Huh?
Earlier, there is a good stands are losses
Unloaded there.
unloaded there losses. Now
Then?
we are going to revive that project. Losses.
He submitted that the land which would be cleared out after eviction of these 21 houses, by eviction of the 21 houses, the goods train station, unloading area would be revived. And as such, there is of urgent necessity, the land is required. He further submitted in view of the proceedings before the First Appellate Authority going on for last 8 years, the said project had to be stalled. In the backdrop of the above, let this court therefore consider as this court have duly heard the learned counsels appearing on behalf of both the parties. Though various points were urged before the learned First Appellate Court on the grounds of violation of natural justice, that the land is government land, as well as the notice under Section 4 was not in accordance with the provisions of the Act of 1971. The petitioner counsel for the petitioner is not raising the said issues, taking into account the findings so arrived at. Be that as it may, this court, be that as it may, this court also have perused the impugned judgment, more particularly the analysis and determination of point of determination number C. And this court finds no infirmity in the judgment dated 19/6/2024, passed in Miss Appeal number 4/2016. The reason for making the said observation is twofold. First, the learned First Appellate Authority have duly considered the evidence on record as was placed. Secondly, the petitioner herein, who were the appellants, completely failed to produce any document to the effect that the land in question is a government land and not railway land. Today also, this court duly gave an opportunity for producing any document which would show that it is a government land, which the petitioner had failed to do so. Under such circumstances, it is the opinion of this court that the land in question would fall within the ambit of Section 2E of the Act of 1971. In the backdrop of the above, let this court consider the submission of the learned counsel for the petitioner. The counsel for the petitioner has submitted that the petitioner have been singled out in carrying out the eviction proceedings. On the other hand, the learned counsel appearing on behalf of the respondent submits that not only the petitioner, 21 other houses are to be evicted, for the purpose of reviving the goods train unloading station. You got an instruction written.
No, I have the telephone instruction as per lordship. Yesterday directed us to lordship,
Huh?
telephone instruction.
I'll do one thing, get a fax or whatever may be from them, get 21 thing.
Lordship,
I'll put it on record.
lordship,
I'm taking remaining this at 2,
lordship,
okay? Remaining I'll pass it
lordship.
and mark that and keep on record, the 21. 2 o'clock. 2 o'clock, let me put it on record.
Lordship,
Get it by fax, or what do you call WhatsApp,
lordship.
and then produce it. I'll just put it on record. Because then he also should have a satisfaction that he had not only been singled out.
Lordship.
Like any my DS, huh? The DS. He too, in the meantime, he get a idea. Yes, next.
Item number 2 for motion.
Yeah. What is this? 3C, 3D. Oh, here's me.
Lord, my lord, one katha land had been acquired by the National Highway Authority of India, my lord. And, my lord, the amount of compensation which had been given, we are not happy with the same, my lord. That's why by invoking the provision of section 3Z of the National Highway Authority Act, my lord, we have raised a complaint. But that has not been adjudicated, my lord. There is a provision that complaint can be, my lord, referred to the arbitrator also, my lord. That much, my lord, and we are not,
You have given to them.
my lord.
Kala, who is the Kala? You. If you have given, why you are not taking it up? Send it to arbitration. Isn't it? Or we can do one thing. On the basis of that, yes, you have not taken any action, ask him to file it before the arbitrator. Special officer, secretary,
My lord,
Ashok
the
Kumar Burman.
arbitrator is required to be appointed by the central
Eh?
government.
Notification is we arbitrator.
So you do that.
My lord.
Your problem is solved.
Yes,
Why
sir.
should we go for the issuance of notice in this type of matters?
My lord, they are coming with by way of a demolition, my lord. So that's, I have annexed some photograph, my lord. My neighbor's property has already been demolished. Now,
Why won't they demolish? They have already taken your land.
the possession has not yet been taken
So
over.
they will take over the possession.
My lord.
3D has come.
3D, no, my lord.
Huh?
3 section, my lord. The E is there, my lord.
3D has come.
There.
The moment 3D has come,
Fine.
3F automatically follows.
My lord.
But only Millard here,
Huh?
this, yes, they have made the NSN, National Highway Authority of India is party. But this is National Highway of India is not, the constructing agency in Dubri area. That is just not paid right party also, it has been NSA itself. Whether it will be required or not is immaterial, but now presently NSA is not constructing in Dubri. That's not true. But if my requirement is there in suppose before arbitrator or whatever, they have to implement right person because we are the requiring agency,
Right.
NSA DCL. Then there we have to go there before the arbitrator. Because regarding compensation will come, it will announcement, we have to there. That is a first let him make party, proper party, my lord. NSA
3D has come.
My lord.
3D has come.
Notice-
3D has come. nothing.
Page 47, my lord, is the last notice, my lord.
or he can go straightway addition, my lord, as lordship suggests. He can straightway go addition, or not to,
My lord,
yeah, he can go, what is there?
declaration,
Where is the representation?
my lord,
this
is
one,
that-
na?
yes, yes, my lord, is that page
17.4.
17 4, my lord,
They are not taking any action.
my lord. That can be referred to also, my lord, by the
No,
authority.
not like this. They will have a problem, or I can ask them to refer it.
Yes, yes, my lord.
But then also there is a problem. If I ask them also, then how do you know?
My lord.
In fact, when you file this type of thing, you should not ask that. You should file in a more of a complaint of a something like a plaint,
Plain, plain.
that this is how your amount is. This is not it's not a representation business,
this-
nah.
This, when it will go,
This
this
is
will
like a
come from it.
reference.
For which-
That will become your plaint of that.
Mile,
proceeding.
mile.
This is
That is
actually
right.
how this filed.
That is correct.
You do one thing.
Mile.
Demolition too, they will do it. Don't worry on that. 3D has come. So you do one thing, taking into account this, you make this person rightly a party.
And it's a detail.
NHI.
So that it will be there.
Where?
it will be helpful.
Huh?
Here your lordship will get it. That's one number 2 they have made. They may not be aware, I think that is why they made it. National Highway
Fine.
of India. That should be, address should be, I'll give now.
NHI
detail.
Okay. You can very well do one thing. You can just change it.
Yes,
Mile.
but sending also,
I can make him a party,
Mile.
but you have to file a fresh memo parties.
Yes, sir. The
Okay.
first title I will this amended 1 million.
I'll give him address.
Mr. C. Borua, the learned counsel appearing on behalf of the National
Contempt.
Highway Authority of India submits that the acquisition proceedings which have been the acquisition proceedings in respect of which the instant petition has been filed, it is not the National Highway Authority who are the acquiring authority, who are the
Requiring,
acquiring authority,
requiring.
requiring authority. But it is the National Highway,
Infrastructure Development, NHIDCL,
National Highway
Infrastructure Development. Corporation
Infrastructure Development Company
Corporation
Limited, who ought to have been made a party.
Party.
First, Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner, submits that as the petitioner had no knowledge about the same, this mistake had happened. So and as such requested this court that that the petitioner, that instead of National Highway of that National Highway, name of the National Highway Authority of India as appearing in respondent number 2 be deleted, and in place of the National Highway Authority of India, the National Highway Infrastructure
Corporation Limited.
Development Corporation Limited be made a party to the instant proceedings.
Right.
First, this court, having taken note of the submission of Mr. C. Borua, is of the opinion that the interest of justice would be met if the respondent number in National Highway Authority of India is struck off, name of it is struck off, and instead the National Highway Infrastructure and Development Company Limited, corporation or company?
Corporation Limited.
Corporation or company?
Corporation Limited.
Corporation Limited is made a party to the instant proceedings. Accordingly, this court strikes out the name of the National Highway Authority of India from the array of parties and impledes the National Highway
address I can
Infrastructure
give.
Development Corporation Limited having its office at anybody office?
No, I know.
Oh.
And I said, I'll appear. I'm not telling how important. That is why this will be Project General Manager P in bracket.
Represented by the project general manager.
General
P.
Manager P, Project Monitoring Unit Dhuburi, NHIDCL. I'll give him address.
No,
Or I think I'll give
photo,
them.
photo.
I'll give them. Right.
As the respondent number 2 to the instant proceedings.
Fine.
So, in that view of the matter, this court directs the petitioner to submit a fresh memo of
Fine.
parties by 2nd of September 2024 before the registry of this court, and the registry shall thereupon make necessary correction of in the cause title of the writ petition and also update the same in the CIS. Full stop. The matter be again listed on 6th of
Fine.
September 2024.
6 may not be. I'll be out of it.
Who are you?
For Union of India.
Union, I have not issued
My
notice.
lord,
I
may-
don't know.
May after 6th.
After 6th, 9th?
Right.
Yes, 9th.
Oblige.
Item 3,
Yes, what is this?
My lord, there was a partition case pending before the Calcutta High Court, my lord, in respect to the property of Maharaja Gauripur, my lord. Properties were Kolkata, Assam, and various other places. So, my lord, during the pendency of that partition administration suit, my lord, where under the orders of the court, my lord, Commissioner submitted his report in 1977. And then, my lord, prior to that, preliminary decree was passed. Now, during the pendency of this partition suit, my lord, the government of Assam, my lord, has, my lord, negotiated from one of the co-sharers for direct purchase in respect of a property at Gauripur, my lord. We raised objection. Then the DC Dhubri, he, my lord, taken up the commissioner's report, part of the commissioner's report, which was to be interpreted, objection has to be filed before the trial court executing the partition court, my lord. He has interpreted a part of the commissioner report and said the land which the government wants to purchase belongs to the respondent here, one of the co-sharers. Though, my lord, there has to be subsequent amendment of the decree passed, preliminary decree passed. The court has to determine who owns the land. They may not directly purchase the land from those co-sharers. Then, my lord, we raised it after coming to know about this. We raised objection, filed representation. They, without hearing us, without giving an opportunity of hearing, said the land doesn't fall in the share of our predecessor interest. It falls in the share of their predecessor interest. And accordingly, they made a direct purchase. They could not have made during the pendency of the suit when a preliminary decree has been passed. But final decree has to be passed because on the basis of commissioner's report, the parties will have an opportunity to make their submissions before the court in respect to the commissioner's report. Without, my lord, allowing us to, my lord, go there and raise our objection and all, they made, my lord, direct purchase from other the co-sharers, who in fact are not the co-sharers, because they said their land belonged to some Parikshit Chandra Badua. The petitioner's father was the foster son of Parikshit Chandra Badua. But in fact, all these things has to be, my lord, determined by the partition court, my lord. And then the final decree has to be passed. Only after that they can initiate, my lord. There is nothing wrong in it. They have not acquired the land under the...
No, tell me first, where is the concept of the revenue?
direct purchase.
Revenue will make the settlement in terms of 54.
54 or, my lord, of the commissioner's report. 54, it doesn't arise because it is not 54.
No, first of all, if it is a preliminary decree, it will come within the ambit of order 20 rule 18.1.
Yes, it is 18.2. 18.2.
No,
Because the
no,
other
it
property.
is not before the revenue authority.
No, they could not have done that, my lord.
So you mean to say that you have the right to object under order 26 rule 13?
Exactly, my lord. Exactly. Without doing that, and because it is not in because the court apparently sent it to the commissioner under order 18, order 20 rule 18.2.
Let's see that all.
My lord, lordship will see the speaking order, page 90.
Preliminary decree.
Preliminary decree, my lord, page 175, based on a, my lord, settlement made between the parties.
Let us see the preliminary decree.
175, my lord. No, preliminary decree. Now, with the settlement, terms of settlement. Terms of settlement is the preliminary dictum, my lord. In fact, Lord, you will find. Yes, this terms of settlement is the preliminary dictum, my lord, page 90,
Page
94.
94.
And
Where is the appointment of a commission?
commissioner appointment, that order is not there, but the report is there, my lord.
Huh?
Commissioner. Commissioner's report is there, my lord.
No, commissioner, no. Where's the appointment of a commission? Then only I will know whether it is order 20, rule 18 or 1 or 30 or 2.
Commissioner appointment, what I said, commissioner appointment.
Where is the
But
court order?
My lord will kindly see the page 90 order, speaking order, that will reveal everything.
Page
90. The relevant part is page 91, my lord. I'll read page 91, my lord, from the first paragraph. Whereas on 17th of October, a prayer petition was received in this office from Srimati Moshumi Burua Roy is the petitioner, daughter of Arup Kumar Burua, who is also another son of Raja Prabhat Chandra Burua. In her petition, Srimati Moshumi Burua has stated that she came to know about the purchase of the Hawa Mahal by the government from media reports, and that the sons of Prakritish Burua had gone ahead with the negotiations without settling their family property dispute. Srimati Moshumi Burua mentioned about a decree by consent passed by the Honorable Calcutta High Court on 28th of Day of 1963 in administrative suit number 993/1960, Srimati Jamuna Burua versus so and so. Srimati Moshumi had submitted a copy of the terms of settlement. Whereas the original decree of the terms of settlement, it is seen that the page number 2 of the first schedule, the land under Satyan number 365, Dag number 560, 562, total land of 26 Viga, 317 lesser, is given under joint names of Kumar Prakritish Chandra Burua, Kumar Pranavesh Chandra Burua, and Srimati Madhuvilata Burua and 3 sons. Whereas the sons of Prakritish Burua, represented by Prabir Burua, were sent a notice regarding the terms of settlement and adherence thereof on 30/11/22. In response, the Prabir Burua submitted on auto a copy of return of commissioner of partition dated 28/5/77 of Sri Pratul Chandra Datto, advocate commissioner appointed under the order dated 28/8/1963 with annexures filed 1st of December 1989. This return file is also one out of the original administrative suit 1960, Honorable High Court, Calcutta. Whereas on perusal of the above return in page number 6, in second schedule, it is mentioned under portion of Rajabadi and compound at Gauripur and Motiabag Palace and compound allotted to Kumar Prakriti Chandra Burua mentioned has been made a Khatiyar number 365, 560, which corresponds to post resettlement of new Dag number so and so, which are under consideration for the purpose of this acquisition of the government of Assam. Whereas another complaint was received from one Kanchanmala Burua, who reportedly is the daughter of Prakritish Burua from a different wife. Whereas in response to the said claims, Prabir Burua submitted a will executed a late Prakritish Burua when probated by the Honorable District Judge, which mentions that the inheritance of all the landed properties in Motiabag, only 4 sons, namely Pradeep Burua, Prabir Burua, Pradut Burua, Pratim Burua will get the share so and so. Hence, from the above 2 documents, it is established beyond doubt that the aforementioned Dags of Motiabag, Gauripur, the 4 sons of Prakriti Chandra Burua are the rightful beneficiaries. How the court can determine this, my lord? On the basis of commissioner's report, my lord. Prakriti Burua of the compounds, the 2 complainants received do not stand. And so, and that too, my lord, without hearing us. And this has to be determined by the Honorable Calcutta High Court in the partition suit.
Now, how is the government acquiring?
Government direct purchase, made direct purchase from them, my lord, this
How?
two. I do not know, my lord, because
They are purchasing government. Direct. From them.
From the successors in interest of the person, my lord, to whom, my lord, the property was given by dint of, my lord, the commissioner of partitions report. And he executed a will.
Will was probated.
Will was probated.
Probating of a will would only convey a title, would convey the rights of the person, whether he has it or not, that is another aspect.
Another.
But it would only convey his intention
Correct.
that there is my rights which I get in respect to this property should also vest on them. But it does not
All
confer a
court answers.
title on that property on the basis
Correct.
that.
As your lordship has said, your lordship has put a question that how the appointment of advocate commissioner. This appointment was of 1963. I don't have a copy of that
No,
appointment
that
order. That has-
subsequently there are
They challenge that
some
it's a
other.
different thing. Otherwise, the person, from the return of the commissioner, it appears that person who got Prakritish Barua, this Matiabag, this has been given by him to his sons by way of a will. And from them we have purchased.
2024.
Same property. It is there in the return of the order. So he has got that property
Page-
per person to the
Page
partition.
261.
Take the last one.
My lord,
Now, Mr. Roy, what are you challenging?
my lord, I am challenging this speaking order because I initially approached the Calcutta High Court challenging their decision. This speaking order has come, my lord, only by way of an affidavit in opposition filed there. The Calcutta High Court passed an interim order with status quo. The case continued. After that, the Honorable Calcutta High Court said there is lack of territory because the order is passed in Guwahati, therefore Assam. So this court is lacking in territorial jurisdiction. Therefore, my lord, I had to come before this lordship. And the last order, your lordship, kindly have a look at the last order.
61.
261, page 261. This is the order passed, my lord, on 6th of August 2024. So, Joint Commissioners are directed to circulate the report respective parties. My lord, but this is still pending, my lord. So, we'll get this report. We'll have our say before the court, my lord.
Now, why this speaking order came into it?
My lord, since I raised an objection,
Hmm.
when I got this information about this, my lord, their proposal to purchase it, I raised an objection, representation I filed. And while disposing the speaking order has been passed. And where everything rights have been determined. And that too, my lord, without, my lord, at least an opportunity of hearing ought to have been given, that was also not given.
Third, if the
And the person that petitioner interest died long back. Our petitioner also died. There has to be an amendment or, my lord, the decree. There can be two preliminary decree also. Their right has to be, my lord, determined by the court. And the preliminary decree, our right is determined, our predecessor's right is determined, said we are also co-sharers. That remains undisputed.
You see, there is no outright purchase, it is acquisition. Kindly see page 91.
page 61, lordship, kindly, how it
No,
was
page
acquired.
91. The first paragraph.
Page 90. And this is your lordship seen from the speaking order. The actual notification is there at page 61. From there it has been sent. In lordship has got my page 61.
It's a scheme of the government in pursuance to cabinet decision dated 12/1/2022, taken on additional item number so by file number the Water Resources Department, Assam. The governor of Assam is pleased to order land acquisition through direct purchase by way of negotiated settlement for all departments in the state of Assam, as enumerated in the enclosed document in Annex 1. It will come into force with effect from the date of publication of the notification in the Assam Gazette and will remain in operation till such time as the state government may consider fit and proper. The government reserves the right to make any amendment to the same from time to time. Land, it's just an Assam Mala project, man.
This is in violation of Article 166.
These are not on a challenge, my lord.
This is challenge.
It will.
Not in the name of governor, not authenticated by the secretary and all.
And then also we'll kindly see the Gazette notification, page 71. Agreement with the landowners. This is how the agreement will be executed. Then page 75, circulation direct purchase price. It was purchased at a cost of 15 crore. But this is, we are making it as a heritage site.
You make whatever may be, that is
Madam.
a different thing. I'm not
Madam.
on that.
Madam.
But the thing is,
Madam.
this notification has been published.
Yes. These
And-
things are not on a challenge, my lord.
And no, it is not under 166, not in the name of governor, neither authenticated by secretary and deputy secretary. My lord, kindly see.
Madam.
That of course, my lord, I can about.
They're not on
In the
Chile.
name of the governor, government of Assam.
No, no, my lord, there has to be, in the name of the governor, it has to be authenticated. They're under the rules of executive business says, if the governor is Assam, it has to be right like this, but it is too technical, but has to be authenticated. How is the second signature of the secretary or deputy secretary? None.
This is a type copy.
Type of the original of
We
there,
can-
my lord.
Where is the original?
Original, see the original Tassanala.
Otherwise, how is it published? And what do you say about 166(2) of the constitution?
Lord, it has to be under the rules of business. I've got the copy of rules of business.
It's okay. First, let us see the constitution.
Yes.
Rules of- Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in the rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the government.
Rules of business says, Rule 11, all orders or instruments made or executed on or behalf of the government of Assam
That's
shall
the
be
61.
166. This is
This is
based
the-
on
This is the 61 rules.
Rule 11.
Is this the 61 rules?
68 rules
60.
of executive
Now
business.
what is it? 2015.
My lord.
You have a different rule now.
Yes, man.
This, I don't think this is changed, my lord. They-
No, they have a different rule.
They have, we have. Today, my lord, just now, lots of
The
taking
rules
them
of
on Monday, man, I'll
executive
bring
business
our,
is changed.
my lord, before the,
I
yes,
think in 2015 or 21 or something, you came up with a new rules of
Different.
executive business.
Yes, let them go place that rule, my lord, because
my lord,
I don't think this rule would be changed because 11 and 12 would be in terms of the constitution.
Understood, but that, as of now, that rule I think is not holding the field.
yes.
Maybe. This is 1968 rule. I think.
That is it.
That
Because
is, you know-
I was also under the impression that day, somehow I got hold of a new rules of executive business, isn't it?
Then-
The Bolpuzari?
Well-
Isn't there are new rules of executive business, Assam rules of executive business?
Some amendments have been carried out. Now here, my lord, the lordship has seen this gazette notification. These are type copy. Now, my lord,
Which
on
also original.
on the same facts and circumstances, they had moved the Kolkata High Court, challenging the decision, earlier original decision of the state of Assam to purchase their property by way of direct acquisition, my lord, by dint of this gazette notification. That, my lord, initially one status quo order was passed. Then it continued. Thereafter, my lord, finally, in the month of June 2024, that writ petition, my lord, came to be dismissed on the ground of lack of territorial jurisdiction as well as on other aspects of the matter that is a part of the writ petition. having my lord suffered a defeat out there, my lord, the petitioners are now before this honorable court. This
And
is how-
defeat mean on a technical ground.
my lord. Now, there, my lord, there we have find a detailed affidavit. The, my lord, enumerating the entire genealogy and the chain of events, how we came to purchase that property. We have find a detailed voluminous affidavit. There, my lord, things will become clear. Here, my lord, lordship may be please at this stage, my lord, to give my lord notice of motion, my lord, we will find a detailed affidavit because all the part and parcels of those affidavits, all those.
These are not here.
But these are not here, my lord. We have filed everything, we have
No,
got everything.
understood. But what is this direct purchase method?
Direct purchase method, my lord, instead of acquiring, my lord, we may go for, my lord, with a negotiated settlement. First of all, my lord, we have to identify the part and parcel of land, then the pattadas. If the pattadas agree.
Understood, understood. Now kindly see here in that gazetted notification.
Yeah.
Page 61.
Objection for everybody.
Kindly come to number 6, page 63.
Yes.
General notice.
The lease shall be published inviting objections, if any, regarding
Ownership.
interest and ownership of the land, etc. From receiving objections from the landowners, a waiting period of 1 month shall be given.
Yes.
Now there is an objection filed.
Yes.
Now the objection will be decided by the,
By the collector.
now collector gets the jurisdiction from where?
Collector gets a jurisdiction from this notification itself.
Huh?
Yes, because my lord,
Okay.
he will be the person. Kindly see my lord, 63.
Page 63. man.
63. Because there will be my lord.
Start from page 62.
62.
A district level land purchase committee under chairmanship of the
Steps.
deputy commissioner.
Steps
is
are there, my lord.
constituted
Kindly
for
go
direct
and-
No, 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 no. How does the collector gets that jurisdiction to decide on a point of, it may be a case of the entire compensation, apportionment of a compensation, everything. How does the collector gets the decision? And what is the next course available then?
Therefore, my lord, from page.
Therefore, I was asking you, on what basis you are having this thing? You may go for a direct area acquisition, but acquisition stems from where? There's the source of power. The source of power is where? How do you acquire a land?
We acquire land, my lord, it may be worded as such, my lord, that it.
No, 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 no. How does the state acquire the land?
It acquire land, my lord, under statute. Under
Statute,
statute,
statute.
applicable statute. There are statute. Now, here is a scheme, my lord, which say, my lord, it will amount to acquisition by direct purchase, meaning therefore, my lord, the purchase is having an overriding effect. Purchase, the factum of purchase is having an overriding effect. Because once, my lord, it is determined that who is the owner of that property and all the objections are met out, my lord, then, my lord, the.
So then they can file a suit.
My lord,
They can file a suit against you. They can get an injunction against you.
they may. But action of the government, my lord, they can challenge.
Because this order is otherwise not appealable. And the purchase, if their land has been sold out, why can't they file a suit against you?
My lord, may I come in there? So any other case, this question may arise, but in this case, my lord, there was a preliminary decree and it was a consent decree. Now, they can today say either that the decree is bad, and if they say decree is bad, your lordship is aware, my lord, there's a provision for appeal in the CPC for filing an appeal against the preliminary decree. That they admittedly they have not done. Today, if they do not say that.
No, no. Kindly come to this, if it is a preliminary decree, if we are concerned that it is a preliminary decree, but however, the commissioner has been asked to find out what is the, or go into the detailing, how much one person is there. That is why I wanted to see the decree as it is.
My lord, I'll see.
As to where, which
Page 1.
portion of the land, how much it will be getting, has to be decided by the commissioner. And the commissioner's report has not been finalized till now. Couldn't it come under order 26 rule 13 and 14?
My lord, I have not seen the copy of the order by virtue of which the advocate commission was appointed. If your lordship goes to.
So that is the most crux. His entire submission is on the basis of the, you will look here, this is the commissioner appointed under 2613. And as such, I still have an objection to file a 2614 and also cross-examine the commission.
Correct.
He can do so. Now, if that be so, then the decree does not become final.
True.
That is one.
My
On
lord.
the other hand,
Right.
if it is a case where it is a meets and bounds have been already found out. And if the meets and bounds have been already found out, then because a decree may be partly final, partly preliminary also.
Yes.
There can be 2 degrees. So if it is a final in so far as certain aspects of the matter where meets and bounds have been found out, but in certain aspects where it is required.
Right.
Just for example, certain property, the building in question where it cannot be only divided by the revenue estate, then you may have to go on various aspects of the matter. OLT amount will come, various other aspects of the matter will come in. So then 2613 will come in. Now, whether this area was the case where there was already a final decree.
My submission will be the report of the commissioner will show that the property which we have got, we are in possession. And there is an agreement between the parties that yes, we are all of us are in respective possession. Based on that, the person who got this portion, this is Matia Bagh, my lord, he has executed a will in favor of his 4 sons. Thereafter, it came in the name of the 4 sons, mutation was there, only thereafter it was sold by virtue of this.
But
notice.
Mr. Mugunda, one thing is very clear, merely because of a probate is a different
No, I'm
aspect.
not on that one. There is a subsidy, as the Lord said.
Because if you see the
I-
last page, the last of the paragraphs
Right.
of that order,
Right.
it seems that the deputy commissioner has assumed on the basis of that aspect, on the basis that there is a probate.
No, my lord. Probate, as your lordship is saying, I am.
No, if you see that last portion of that order, kindly see page 91, the last portion. How does the deputy commissioner come to a conclusion? Whereas in response to this claim, Sri Prabir Borua submitted a will
Yes.
executed by Prokritis Borua and probated by the Honorable District Judge, which mentions that for inheritance of all landed properties at so-and-so, only 4 sons, namely so-and-so. Hence, from the above 2 documents, this document,
My
it
lord,
is established beyond doubt
my lord,
that for the aforementioned Dag at so-and-so, 4 sons are the rightful beneficiary. Then,
your lordship will go just 2 paragraphs above
Hmm,
that.
hmm.
Whereas on perusal of the above return, as the lordship got mentioned this
Hmm.
part. In page number 6 in the second schedule, it is mentioned under portion of Rajbari and compound at Gauripur, and we are concerned with Mathiabag Palace, my lord. Mathiabag Palace and compound allotted to Kumar Prakriti Chandra Borua mentioned has been made of Khatian number 365, Dak number 560, which corresponds to the post settlement, resettlement, new Dak number so and so, which are under consideration for the purpose of this acquisition by the school. I am on this, my lord.
Sir,
After that-
this is a returns. What is this return? Above return of what? What is this return?
Commissioner,
So
commissioner,
commissioner's return, isn't it required to be finalized?
my lord. By a final decree, my lord.
Yes.
My lord, my
It has to
suspect-
have the authority to that effect. Then only the second document, which he is relying upon,
lord.
will have any effect.
My lord, I respect to submit one thing, my lord. If this part of the order of deputy commissioner is correct, then 2 things are coming up. One, he is in possession of the area which he has got. Thereafter, my lord, final decree may be proceeding, it's a formality only, but so far as the right of Prakriti Baru is concerned, is established.
No, not on the basis of a commissioner's report.
It's the preliminary decree. He is only saying that he has got it.
No. Where is the preliminary decree showing that
Madam.
this aspect? Show me
Preliminary
that aspect of the matter.
Preliminary
Preliminary
decree
decree I have
shows
not annexed.
their predecessor and our predecessor together will have.
There. Therefore, my question was, why should this court have this? Where is your power to acquire? On what basis do you get a power to acquire land? You may have many things. You may go for a direct purchase. He says that I am going for a direct purchase. Then if it is a case of direct purchase, then he would have a definite right. Then the state comes into the standing of a normal person and direct purchase, then he can very well file a suit anywhere.
My lord, in a normal case of direct purchase, where before that purchase proceeding, if he did not have any opportunity of putting across his right, etc., then his question of hearing is one thing.
Understood.
Here is a
No,
case.
no. Where, how does this deputy commissioner get the jurisdiction to decide this?
My lord,
On the basis of a document?
my lord, I'm just a stage prior to that. What I am saying is, my lord, there was a partition suit admittedly. In the partition suit, a preliminary decree has been passed. Now, if in the preliminary decree, Prakritish Barua's portion has been determined,
Where? Show me that.
that means there's partition.
That you were saying many things here, that is not clear.
My lord, just I'm showing from the preliminary decree is not here, it ought to have been annexed by them, if they are saying something is wrong in the decree itself. My lord, page 173, what may kindly able. The return of the commission, from there I'm showing what may be there in the preliminary decree before I produce.
170.
173, my lord.
Original administration year, return of the commissioner of partition number of Sri Putul Datta Advocate Commissioner appointed under remand.
Now, Lordship may kindly see page 175. Just the middle paragraph, my lord. Whereas by preliminary decree for partition passed by the Supreme Court in the above suit number so, I was appointed the commissioner of partition to do the acts and things mentioned in clause 31. 31 is this one, my lord. Subject to the provisions of these terms settlement and in particular to the provisions in paragraph 28 and 36 thereof, he will make an effect complete partition of estate of Raja Prabhat Chandra Borua and Kumar Prakritish Chandra Borua among the residuary legatees under the will and.
Which paragraph we are reading?
Well, page 175 from the middleman.
Whereas by a preliminary decree
Yes.
for partition.
Partition passed by the Supreme Court in the above suit on 28th of August 1963. I was appointed the commissioner of partition to do the acts and things mentioned in clause 31 of the terms of settlement on the basis whereof the said preliminary decree was passed and which are set out here and there. This is clause 31A. Subject to the provisions of these terms settlement and in particular the provisions in paragraph 28 and 36 thereof, he will make an effective complete partition of the estate of Raja Prabhat Chandra Borua and Kumar Prakritish Chandra Borua among the residuary legatees under the will and codicil of the Raja Prabhat Chandra Borua and Kumar Pramodesh Chandra Borua in accordance with their respective shares under the will of Raja Prabhat Chandra Borua and will and codicil of Kumar Pramodesh Chandra Borua, and in doing so shall make necessary adjustments among the parties in respect thereof, respective liabilities to the estate and to any other for the withdrawals or on any other accounts as.
Mr. Muzumdar, the best thing I'll issue notice to you, file your affidavit, and on the returnable date, I'll consider the interim prayer if you are. As of now, I don't find you have a case. He has a case.
I'm showing one approximately. Yes, bear with me. Page 183, 183 or something. And so far as this notification and direct purchase is concerned, this is absolutely in accordance with law.
No, it is not in accordance with law. Where is the way? First of all, this direct purchase business is wrong. Absolutely wrong. Where is your power? That is why you couldn't show me.
My lord, this is an acquisition under 2013 Act.
2013 Act 103 gives the power to the state government to have a better, what do you call a better compensation package than the normal one. Now, it is a package. Nothing more than that.
I'm not.
No, but can you take away or decide the jurisdiction of or the persons or the, can the deputy commissioner decide? That is the question I am on.
My lord, may I just, what I am saying is, my lord, if they are saying that we have got title over the property, then in a normal case of acquisition of this manner, the question of deciding the title will come. Then the question will come, who will decide? here is a case, we are saying that pursuant to the preliminary decree and the commissioner's report, they do not have any title.
Are? No. Therefore, the commissioner, as could be seen from page 175, the commissioner seems to have been appointed in terms with order 26 rule 13. If it is so, he definitely has a chance of filing an objection or cross-examining the commissioner in terms with 14. Have a look at the CPC.
Well, I'm aware of that. What I am saying is, my lord, it is another thing that if it is a revenue paying state, whether order 20 rule, 18 rule 20, first part or second part would have come, my lord.
First part.
No. Therefore, I'm saying
Minor.
there might be, at least it order 20 rule 18.
My lord, order 20 rule 18. Two.
2 says that in a case where there is a certain immovable properties and immovable properties, then in that case, what the court is going to do, they will pass a preliminary decree. Then you don't come under it doesn't come under order 20 rule 18(1) and 54 is not attracted.
Order 26.
Then you have to go 26(13).
My lord,
There the problem arises.
Yes.
That is his case.
Okay.
well, if that is his case.
But my main question, you see, if the power would have been exercised by some court, which ought to have been, therefore I was asking, this acquisition which you are making by direct purchase, the direct purchase can be, you can very well do it by way of, it's normally a consent. Direct purchase is a consent,
My lord.
which is the Assam Mala scheme and all.
Yes,
But in view of a consent, which you see it parametered to section 12(2) of the earlier act of the Land Acquisition Act 1894, there is a consent award. Now also it is permissible under the new act of 2013 for consent award. So therefore you draw the consent award. But when you file, there is an option that you file objection. If somebody raises an objection that I have a title, how can the deputy commissioner decide? It will have far-reaching consequences. You are asking the revenue authorities to decide.
therefore I am saying, if they are saying that whatever has happened before the either executing court or before the court which passed the preliminary decree, if there they say that we have a case that we have a right over the property, this property, then the matter is different. Here is a case, my lord, this partition suit preliminary decree proceeding, etc., is going on for years together from 63. This report is when Lord Lordship is in 89, he was appointed.
Yeah, that is the best
And-
part. That is the best part of Calcutta High Court.
And my lord, this is order. Well, we have started after purchase, we have paid 15 crore after we
You
purchased.
are there in that
People
matter,
are-
na?
My lord,
The Hemen matter. There. The probate is going on
my
for
lord,
all these
suddenly I was
things.
gonna, I had to get I argue from there. Hello, what has happened in this case? The Deputy Commissioner Dhubri has passed the order. Instead of challenging it here, they challenged it there and then obtained.
No,
a
they did
status-
not challenge.
status quo.
No, you've not challenged that.
No, the
We are
petition was filed
challenging
by
it
them.
These,
But this petition, instead of challenging that order of DC by petition before this report, they filed it there, obtained a status quo order. We have not.
Anyway, let me issue a notice. But it's an interesting case after
Interesting,
all. It's an interesting case.
My lord.
But there is a big problem with that. With the Assam Mala, if this is the aspect. Because the power has to be derived from
I'll
somewhere.
come up with all the documents, including preliminary decree. Well,
No.
my
But,
endeavor
unless
will
the
be-
preliminary decree
Well,
says on the basis of a settlement that this area is his,
Well,
then it is outside the commissioner's thing. Outside that commissioners to look into
Yeah.
it. He cannot
This is
decide
final.
that aspect of
This is
it.
final.
But it
That's
may
what
be a
I'm saying.
case where
my lord,
a
that-
person may be given these by
Well,
way of the terms of settlement, and
My
on
lord.
the basis of that, the commissioner will only look into the question of OLT to be paid to somebody else on the basis of this being given to this properties.
What your lordship has, from what you lordship fallen from your lordship first part, that through the preliminary decree, we have got, this person has got it.
Yeah.
And thereafter, he executed a probate. I did not purchase on the basis of probate. Their father got it through the preliminary decree.
But you see, the deputy commissioner bases on two aspects. First is the
Deputy
return of the
My
commissioner,
lord, Deputy Commissioner did not,
but that is the order he is challenging.
my lord, it's challenging, but then if he doesn't have a case on merit about the title, my lord, even if there is some mistake here and there in the Deputy Commissioner order, he
The
cannot.
deputy commissioner order, if that is so, the basis on which he has done is on the face of it wrong.
I'm not.
First, he is doing, he should have done it on the basis of preliminary decree.
My lord,
He did not.
Well, he has.
He has done on the basis of the commissioner's report.
He has mentioned about the probate, etc., but the previous paragraph he said.
No, he says about the return of the by the commissioner. These are the two documents on which he makes his entire basis.
This law which we are discussing, my lord, with all respect, my lord, deputy commissioner will not know that whether. it
That is the reason why I said why it is before the deputy commissioner. It should have before a judge. That is
My
why.
lord,
That is why
that is the
you
right
are
way.
you have form up a police. That is you can very well have a very good package. That we are the state government of Assam. We have got lots of money. We'll give more money, not what the central government says. We got lots of money. We'll give more money.
Well, I'll
Like
come up-
yesterday, that 50 lakhs COVID thing. We got many money, much money. We'll give it. Now, you can very well do that. You have done it rightly. There are many other states is also doing it. But then also, can you take away the jurisdiction?
My lord, my submission in this case will be that petitioners do not have any right over the land. They are just filing one petition after another to all the proceeding. I'll show from the preliminary.
Now, the
decree-
problem is,
My
you
lord,
see,
my lord.
why the others are made party?
They are the
8 to
beneficiaries.
13.
And endeavor is to just to halt and find out if they can just.
Huh? They are your cousins.
They are successor interest.
Okay. Served by Dusty. They're cousins.
Those things.
Okay. Short notice. Issue notice returnable on 25th of September 2024. Mr. Who appears for cultural?
We appear for 1 to 7, all. All the official respondent, government respondent.
How? How are you appearing for all 1 to 7?
But I am assisting the learned.
He cannot take notes. Is he,
But I'm just.
have you given up your gown?
But I have indicated, I'm just.
No, have you given up your gown? Then how can you
Lordship will bear with me, ma'am, let me see, ma'am. One, I'm representing, 2, 3,
Yes, no, wait. Miss so-and-so, you are appearing cultural affairs who?
1, 2,
No.
3, my lord secretary,
Okay.
I can represent.
Mr. Arbor Puja, Miss S. Purua. Mr. D. Muzumdar, assisted by Miss S. Purua, appears on behalf of respondent number 1, 3, 4, 5, 6, 7. Mr. Arbor Pujari appears for respondent number 2.
Lordship is-
As the respondent number 1 to 7 are duly represented, extra copies of the writ petition be served upon Mr. Arbor Pujari and Ms. S. Purua during by Monday, date to deliver. As regards the respondent number 8 to 13, the petitioner are directed to take steps by way of Dusty, routed through the registry of this court and file an affidavit of service on or before the state. Full stop. The petitioners herein, how many petitioners?
2 minutes.
The petitioners herein have approached this court challenging the order dated
8,
8/12,
8, 12,
8/12/2022. Challenging the notification dated 7/3/2022 issued by whom? Who has issued that notification?
That's why.
Issued by the Cultural Department of the Government of Assam, issued purportedly by the Cultural Department of the Government of Assam, as well as the order dated 8/12/2022 passed by the Deputy Commissioner, Dhubri District. The case of the petitioner primarily is that the land which the state government wishes to, which the state government by notification dated 7/3/2022 seeks to acquire by way of the direct purchase could not have been done so, taking into account that the decree that taking into account that the private respondents herein does not solely have any title over the said land. Pusto. Mr. P.K. Roy, the learned senior counsel, submits that a perusal of the impugned order dated 8/12/2022 would show that the Deputy Commissioner Dhubri had decided the said dispute, said objections so filed by the petitioners on two documents. First is the report submitted by the Commissioner in terms with Order 26, Rule 13 of the Code of Civil Procedure 1908, which is yet to be approved by the court, and this aspect of the matter would be seen from the order dated 6th of August 2024 by the High Court of Calcutta in CS/993/1960. Further to that, the learned counsel submits the second document on the basis of which the Deputy Commissioner had come to an opinion and passed the impugned order is an order passed in the probate proceedings. The learned senior counsel submitted that it is well settled that the probate proceeding, order passed in the probate proceedings cannot decide the title of a property. The learned counsel therefore submitted that as in the instant case, the basis on which the impugned order dated 8/12/2022 was passed is on materials which are totally extraneous, and as such, the impugned order dated 8/12/2022 is required to be interfered with. In addition to that, the learned counsel, senior counsel appearing on behalf of the petitioner further submitted that the Gazette notification dated 7/3/2022 is not in consonance with Article 166(2) of the Constitution, in as much as there is no authentication which is required. And as such, it cannot be said to be an order of the governor. He therefore submitted that pending the decision in the proceedings before the Calcutta High Court in CS number 993/2019-60, the respondent authorities be directed not to change the nature and feature of the property in respect to the part and parcel of the land measuring 75 bighas, including Hawakhana, known as Matiabag Palace, under Dag number 560, Khatian number 365, 366, and 367, situated at Matiabag of village Goripur, Part 2, in the district of Dhubri. On the other hand, Mr. D. Mojumdar, the learned additional advocate general, submitted that the right which the private respondents acquire on the land in question is a right which the private respondents got on the basis of the preliminary decree. It is on that basis the Prokitis Borua, the predecessor in interest of the private respondents, have what is the term called? The land means by will you given bequeathed the land the land as well as the palace in favor of the private respondents.
These four sons.
And this will have been duly probated. Full stop. These aspects of the matter have been duly taken. He, however, submits that the preliminary decree having not been placed before this court by the petitioner, a perusal of the same would clearly show that, and as such, the same is required to be brought on record. He further submits that taking into account that any stay order at this stage, without the government being given an opportunity to, he further submitted that any interim order passed at this stage without the government being given any opportunity to file the affidavit would be prejudicial to the interest of the state. More so when there is a requirement for maintenance of the palace, which would be palace in question.
We have paid 15 crore in purchasing.
Huh?
We have paid 15 crores in purchasing.
Pay more, pay another 5 to him, matter solved.
They
You have
were-
lots of money.
they
Government,
were- no, they were never came forward to ask for money. We would
no,
have
they came, and that is why they filed objection. Pay money.
We'll find out.
You are agreeable on 5
My lord.
crores? So, taking into account the above, this court, taking into account, this court is also of the opinion that an opportunity be given to the state to place on record their stand on record their stand before passing any interim order. Full stop. Accordingly, on or before the next returnable date, the state is given the liberty to file their affidavit. The private respondents also would be at liberty to file their affidavits. It is, however, made clear that if the affidavit is not filed on or before the next date, this court shall take up for consideration of the interim prayer on the basis of the materials already available on record.
And, one correction that notification by Revenue and Disaster Management Department. That notification of 7th March 2022 is by Revenue and Disaster Management.
Equity,
Obliged.
Lordship fix the matter on
25th.
23rd, 25th, no?
25th.
25th.
Yeah, 4.
Yes, what is this?
In this case, my lord, victim compensation has been awarded, but the whole amount has been fixed, my lord. And in this case, my lord,
It has been fixed.
has been fixed in their names, my lord. The dependents of the deceased, my lord. Your lordship will, can you say, they file a representation before the before the DLSA and SLSA, my lord. But this thing was rejected, my lord.
Huh?
For withdrawal of the compensation amount, my lord, as there is some urgency, and also fooding and clothing for educational expenses, the money is very.
Whose
difficult,
educational?
my lord?
Whose educational expenses?
My lord, the dependents, in whose favor the compensation is awarded, my lord.
Huh?
In whose favor the compensation is awarded, my lord. They are both minors, my lord, till today, my lord. This is the grievance, my lord.
How much?
Well, 5 lakhs has been awarded, my lord, 2,50,000, 2,50,000. Whole amount has been fixed in the UK bank, my lord.
Very well, good.
My lord.
Then?
My lord, at page 14, your lordship can see the order itself, the
I figure the grandmother aged about 70 have no source of income and unable to maintain them from every side. For maintaining them, I shall borrow money from others. There is a grocery shop balance as well. At present, I am unable to fooding, clothing, so and so. Who are you?
My lord, I am the grandmother, my lord. I am the grandmother. I am the grandmother, my lord, of the
I
dependents.
submitted this earlier before your authority consider the same and release 4 lakhs out of 5 lakhs for their livelihood.
My lord.
It has been made in whose name?
Check has been made in the name of my lord Iftikhar and my lord Arjina.
In the name of the minors, Your Lordship.
Minor.
Minor. What is their age?
One is 16 years, one is 10 years old. Your Lordship. Arjina is 16 years old, Iftikhar is 10 years old.
Why is it money is required?
Yeah, my lord, they are facing some facing, my lord. This is the problem, my lord.
Huh?
They are facing problem also because of their livelihood, my lord.
Why?
Because the father is in jail, my lord. Mother is killed, my lord.
Father is?
Father is in jail, my lord. And mother is died, my lord. And the victim minors are alive, my lord, in the house of the grandmother, my lord. Because at this moment, my lord, the grandmother does not have any income source, my lord. That is why the whole amount has been fixed.
Let us see. Really shouldn't think about it. Not so easy to get it.
My lord,
Can't it be done something like get
least-
some installment 1,000, 2,000 rupees, something like that?
Also, the interest which is being generated on the fixed deposit, I'll try and find out from by the
So
officers. if that
interest
is
will be
possible.
too less.
No, the interest which is accrued is quite an amount, Your Lordship. That is what he has submitted in page 19. 17 is one of the checks.
No, this was done when? You see, this
About
was done in
36 months.
2024. Interest will be very less on 5 lakhs. How much it would be? It won't be five around on 1,000. Huh?
Amount was paid a long time back. It is 36 months since the matter has been in the amount.
No, madam, kindly page 16 and 18.
Yes,
These FDs were made on 17/1/2024.
yes, correct.
So under such circumstance, the amount will be very less.
That's correct.
So under such, and they may get a sizable amount at a later stage, but they have made it till they attain majority. But something can be worked out so that they get. But one thing, the entire money can't be released.
Yes. Lordship, the one more aspect which I might just like to point out is that the order was made in the name of the maternal uncle. The maternal uncle was the one who had filed the case before the DLSA. Today, the grandmother is saying that the children are residing with her, whereas in that case, before the DLSA, it was the maternal uncle who had claimed that the children are staying with him and he is looking after them. So that's a claim which may have to be verified.
You should notice making it returnable on 27th of September 2024. Home as Bulwa appears on behalf of the respondent number 1. When so appears, Ms. R.H. Chori appears on behalf of the respondent number 2, 3, and 4.
No, only for 2 years. Only for 2. I appear only for 2 years.
What, 3?
No, 3 and 4. They
3
appear.
and 4. 1, 3, and 4. Why this is different? These are all under the
Lordship,
same
all-
authority.
No, all DLSAs have their own, are represented by the government advocates.
Those
I
also
only
lot
appear
of-
for state
1,
legals.
2, 3. 1 and here for you. The petitioner herein is the grandmother of two children, namely Iftikhar Rahman and Arjina Begum.
Iftikhar Ahmed, my lord.
Huh?
Iftikhar Ahmed.
You have written Rahman. I didn't write.
Sorry.
Iftikhar Ahmed, Rahman,
At places. he's written
Iftikhar
Begum.
Rahman and Arjina Begum. Good stop. On account of the death of the mother of the two children, the Legal Service Authority, in view of the Assam Victims Compensation Scheme, awarded an amount of rupees 5 lakhs And the said amount was split between the two children of 2,50,000 each. Taking into account that the children were minor, it was decided that the same would be kept in a fixed deposit of a nationalized bank, and accordingly, on 17/1/2024, two fixed deposits were opened in the name of each of the children. One fixed, in respect, two fixed deposits were two fixed deposits were opened in the name of the children. The grandmother, who is the petitioner, has approached the member District Legal Services Authority by filing a representation that out of the 5 lakhs, 4 lakhs should be given to her on account of day-to-day expenses. It is having not been successful in the said application, the petitioner has therefore approached this court by filing the instant petition. The learned counsel appearing on behalf of the respondents, and more particularly the respondent number 2, shall apprise this court as to what solution can be, what would be an appropriate solution to the issue involved by balancing both the interests of the children for the present as well as in future.
For admission item 5.
May I please, Your Lordship? Lordship, in this matter, we have received an affidavit. We would like to file our counter to it. Your Lordship.
Going to file reply,
Yes,
Mr.
S.K. Chakma on behalf of divorce.
So, appearing on behalf of the petitioner submits that he would like to file a reply. 4 weeks' time is granted for that.
Deeply obliged.
Next.
My lord, I
Oh, this one.
yes, my lord, they have already 10%. That day, I'm sorry, my lord, at page 106. Already 10% they have kept by demand draft.
That 10% is for this restoration rebuilding fund, your lordship, as per rule 58 of the MMC rules, your lordship. The petitioner has to pay 10%. As far as DMT is concerned, there is no such provision where the petitioner has to pay the DMT.
Huh?
There is no such provision given in the rules, where the additional 10 amount in fund of DMT, District Ministerial Trust Fund, the petitioner has to pay. So this, the way we're challenging this one, they can be set aside.
We'll take it up at 2. You are short of breath.
But it's fact, my lord, that impugn order will go.
That impugn order goes.
10% if we have to pay them, we have to pay them. But
They've taken that 10%.
That 10% we have taken.
Taken.
That challenge.
That
the
is
order will
okay,
be-
there is no question of here,
There is
but
no
we
question.
only set aside that.
They only set aside that.
Okay, we'll pass it order.
Very well, Lord.
If I'm not there also, it will
Eh?
work. If I'm not there also, it will work.
Yes.
I'll try to be.
No, it's okay, not necessary.
No, I'll try to
Not
take.
necessary. Mr. Khan can be there.
But that 10%.
But I think he will have the breath by then.
After some time, I have just received the copy, Lordship, after some time. Otherwise, copies already come, Lordship, without signed copies, they are Lordship, they have sending the signed copy, Lordship.
Okay, we'll take it at 3 o'clock. Okay, we'll take it at 3 o'clock.
Lordship.
Item 16, fixed at 2 p.m.
Yes, what have you done in regard this?
A committee had been constituted, my lord, at the same time, my lord, on 27/8. first meeting has already been held, my lord. First meeting has already been held, my lord.
Hmm.
Process is on, my lord.
Is this not the case where there is a direction to do the, give it to them within 60 days?
Not feasible. Committee had been formed and that first meeting has taken place, my lord. They have found that many illegalities, my lord.
Huh?
They have found that some, again, some illegality has been found, so committee had been formed.
Illegalities for what?
I don't have the particular, because the, it's clearly stated in the committee, my lord, the committee comprised of following members. Illegal irregularities in the, allotment.
But you have not filed a review
and-
to initiate contempt.
Well, let me find an affidavit.
Will initiate
My lord,
contempt
the
proceedings.
process is on, my lord.
Understood. Will initiate contempt proceeding. Earlier, I have not issued notice till, or I have issued notice.
Nothing, my lord. When I have not filed, because notice
No,
was.
no, I have issued notice making it returnable.
The steps have
On
not been taken. my lord.
22/7, I have issued notice.
Sir, because affidavit not been, sorry, Wakalatnama have not been filed because the state has not gone. It is straight, the state was sent to, handed over to me, my lord. It should have been gone to the, December, that, sometime now respondent.
I have asked you to take steps by registered post.
No, I have taken statement.
Notice issued to the sole respondent so and so on 22/8.
19/8.
Learned counsel has, the petitioner has not taken steps upon perusal. He has
We have taken statement.
date for orders.
You have to file my Wakalatnama.
Anyways,
We have taken statement.
you have taken steps very late.
No.
Now on 22/8, you have taken. Notice has been issued. So, okay. List this matter. On the standing counsel appearing on behalf of the GMC, are you appearing on behalf of the respondent?
I have to appear, my lord.
No, I'm not that.
Okay.
You have to appear is a different thing. There's a difference out there.
Not-
Earlier, I asked you as a GMC counsel. Now,
not-
are you appearing as a GMC counsel or a standing for the respondent?
TMC council, I am.
GMC. The standing counsel appearing on behalf of the GMC had today submitted instructions to the effect that some meeting has been, that the respondents have found out certain irregularities in respect to the allotment of BSUP flats. And in that regard, a meeting was held on 27/8/2024. Taking into account the above, it appears that the order passed by this court dated 3/10/2023 in WPC number 3185/2019 has not yet been complied with. Accordingly, this court this court has further taken, have also further taken note of the office note, wherein it is seen that on 22/8/2024, notice was issued to the sole respondent. It is, however, not known as to whether the sole respondent has been served with the notice. List the matter again on 18th of September 2024. In the meantime, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service. Pustak. The appearance of Mr. Espora as the standing counsel of the GMC is dispensed with. The respondent upon receipt of the notice is directed to file an affidavit as to why contempt proceedings should not be initiated against him.
18 and 19.
To give a
Except to
copy,
PM.
along with this copy, Dusty Service. Yes, what is this?
No, there's that three-state matter in which lease deed was created. So we have filed our rejoinder also to the affidavit in opposition filed by the.
Oh, that case where that lease was granted, leasehold rights were there.
Yes.
He had only given his leasehold rights or mortgaged his leasehold rights to you.
Yes.
Now you are claiming compensation from claiming a part of your
Sale proceeds. Part of the sale proceeds out of the sale proceeds.
after they
auction.
get it, you want that.
Yes.
What is your right?
Now, first of all, my lord, pray that your lordship takes up the lease deed itself. What has actually been mortgaged as part of the leasehold? Because if I may take up the item number 18 first, because that is your lordship comes to the lease deed, starts at page 67.
Yes.
Lease deed starts at 67.
Hmm.
Take your lordship to page 71.
Hmm.
Where the lease deed actually commences. If I may read this part. Now this deed of lease witnessed as follows. In consideration of the premium of rupees so and so, paid as upfront payment by the lessee to the lessor at or before the execution of these presents. The receipt whereof the lessor doth hereby admit and acknowledge, and further consideration of the annual rent of rupees so and so, only against per kg of made tea at so and so. The lessor doth hereby grant and demise unto the lessee all that the factory sheds, structures, buildings, plant and machineries, vehicles, furniture, fittings, tea bushes, trees, on where as is basis, all as more particularly described in Schedule 1, hereunder written and hereinafter collectively written, referred to as safe fee estate, together with all the rights, privileges, entitlements and benefits as more fully contained hereinafter, and all the easements, interest, rights and facilities appurtenant to or enjoyed therewith for the beneficial use and enjoyment of the said fee estate or part thereof, subject to the reservation specified in Schedule 2 for a term of 30 years from the first day of April 2023, yielding and paying thereof the rent in the form of revenue. So and so. Now, if your lordship comes to the Schedule 1, which
you have read I
have read, my lord, page 71, the page 71.
which
That's not the schedule, that is the part of the
no. Page 71, which paragraph did you read?
In now this deed of lease witnessed as follows. Actually, what has
You are referring to which page? 3366? Page 71, which paragraph? There are many paragraphs. Which one?
The paragraph below came.
Okay.
Premium of this part. This part.
As an upfront on so and so, by the lessee to the lessor or at or before the execution of the lease. And so, and in further consideration of the annual rent of rupees so and so. Yes, then
Now, my lords, therefore, what has been leased is the right to use all this, my lord. The factory, my lords, the plant, machinery, etc., tea bushes, trees. They are not separate. We are not claiming right on the land as such, because only the land part is not specifically mentioned here. But what is there on the land, my lord? Can the tea bushes, can the trees, my lord, be separated from the land? That is one part. Now, what has been sold in the auction by the PF? The entire tea estate has been sold, including the factory sheds, plant machineries, everything. You know, the security that we had with the leasehold, that is gone, that is diluted. It is liquidated, and therefore, as a mortgagee, now my only right remains as a my lord to enforce to follow the auction money and claim my share of it. Because my lord, otherwise what will happen is, well, what has happened in this case, let me just sum up.
Let us take a very simple example.
Good.
Mr. R. Sharma takes from Mr. B. Gogoi, the car on lease. Very simple. A car of 5 lakhs is taken on 1 month or 5 months for lease at 10,000. He thereafter leases out or mortgage this his right, which you take. The car is of the value of 5. He is only going to give him 50,000. And then you claim that you are remaining, I want the entire 2,50,000 or 4 lakhs because he has taken a loan from you.
No.
Isn't that the simple thing?
It is
Why
not,
should I?
this analogy is not correct, my lord, in my humble submission.
How can
because-
the ownership in this respect be transferred?
No, it is not.
It is not a day. He has only taken a leasehold right. You have to take him in the context of a tenant.
No, my lord.
What is a tenant? What is a lessee's right? The lessee's right cannot travel beyond the right of the owner.
You know, he's right of the owner, because in this case, my lord, the money has gone. The term loan of, my lord, 2 crore 40 lakhs went directly in the account of ATCL, my lord.
That is a different thing. He paid him. That is another aspect of the matter. We are not concerned.
Here,
Whether he has paid him to ATCL, ATCL is happy, then how can you take it from ATCL?
now, my lord, two aspects arise, my lord. One is that ATCL, can it keep both the finance, but can it avail the benefit of the finance and also take the benefit of the auction of the PF? Because here the only loser will be the public money of the bank, my lord.
Oh, you can very well take it from that respondent number 7. Take it.
My lord,
Because the respondent number 7 is happy. He says, I don't have to pay anything because the entire amount is being taken care of by ATCL. He has only taken on lease. What right, better right can it be? It can't be. Have to, can he sell by way of whatever may be? Now, did you take the concurrence of the ATCL for that this right has been transferred to you?
Yes. Yes, that the mortgage has been created with the consent of ATCL. That is why the money has gone into the account of ATCL.
Let us see to that effect.
Yes.
Which one?
Yes, that is in this petition, my lord, page 101. Annexure 5.
Finally, see number 3. We state that we shall have no objection to the exercise of any right under the instrument of mortgage against the lessee by the mortgagee bank financial, so long as such exercise of power do not prejudice the rights of so and the government against the lessee under the lease deed. Then
Look, that is for them and the lessee. That is all right, my lord. Here, my lord, the leasehold mortgage is a security interest under the Surface Act, my lord. Prior to 2016, my lord, the section 31 did not even contain the power to lease, my lord, because lease was exempted from section 31. After 2016, lease has been specifically made a part. Because, my lord, for the special type of the cultivation, tea, rubber, cardamom, etc., my lord, financing is required. That is why, my lord, the lease aspect was got into. That is why, my lord, the leasehold rights are mortgaged. Here is a case, my lord, where the entire right that I had as the mortgagee of the lessee has been diluted because of the operation of law on account of the arrears of the respondent number 7. Now, the difficulty is, my lord, that I had an option under the lease deed. One authority was given to us that we could ask ATCL to appoint a different, my lord, lessee to auction or to re-auction it. But that right has now gone with the auction, my lord, that PF, because there is a third-party right has been created. So therefore, my lord, all remedies as far as the leasehold property or the mortgage is concerned are stand diluted.
So you knew it at the time when you made it. You should not have given it.
This,
unless you entered, where's your tripartite agreement with ATCL, that ATCL also gives the land on mortgage to you?
no, the land was not given, my lord, because it is not generally given in this. But the lease deed itself makes it clear, but everything standing on the land is there.
No, lease deed may say so. The lease may have been given, but that is a lease of that land, nothing more than that. Your right is only, you should not have given a loan of so much on that. You have made the mistake. Why did you give the loan?
No, my lord, the money has been given on the basis of the lease deed, my lord. The lease deed specifically.
Understood. It is a wrong opinion which you have taken on that basis. But how can the ATC's right? Because it will have a serious impact. Anybody can do anything.
No, that is there, but the ATCL.
Because kindly see this clause. There is one clause in the lease that by which, 29. If the lessee for the purpose of running and developing the tea garden seeks to obtain loan for a bank or so by mortgaging the leasehold interest on the said tea estate in favor of such bank or financial institution, prior permission for the same is necessary and will be given by the lessor and the industries department to this effect, provided such mortgage does not affect the right and powers of the lessors under this deed in any manner. In case of the mortgagee of such interest to the so-and-so by the layer with the prior permission of the lessor in month, for the sake of so-and-so, such finances shall have no authority or right upon the demised land itself.
Look, the land itself has only not been sold. Everything standing on the land has also been sold because the land itself would not be of that much value. It is the PF has sold in its auction the entire tea estate as a going concern. No, when it is sold as a going concern, actually its value is more. This is not the land value which is.
You must have made a valuation of the property.
Yes, valuation is there. That report we have.
What is the valuation?
Valuation is more than what the PF has sold.
Then you should have objected.
No.
To the PF, don't sell it. Why did you sell it at 4 crores? How much? 4 crores?
No, the one is 6 crores.
So then why? Why did they sell it? Why didn't you object to that, the selling?
Well, we were at that point of time.
You should have thought that I would have got you a better offer so that I can get, ATCL gets, they get, everybody gets.
Here, it's not a question of only the lease. The lease in this case is when it is when the mortgage is created under the surface side, then it gets transferred as a security interest. Security
interest has to be looked into to the extent it is.
Yes,
a person cannot give more than what it is, what he has got. His right is limited only to the leasehold right. You are giving the leasehold right to him. You have taken his leasehold right. This is the understanding. Means when I was a lawyer also, I used to think, how is it possible? The leasehold right is very limited.
Yes, it is limited, but in this
he is just a lessee. His right cannot be equated to the lessor.
Because in this case, the leasehold right stands transferred as a security interest. And further, Section 73 of the Transfer Property Act is also there. Section 73 of the TP Act. The doctrine of substituted security. Now, I cannot claim above the PF. And the only right that I have as a mortgagee who is
that is another aspect of the matter. You can't claim about the PF will have a first charge on that. There's no quarrel with that. That's a well settled. I'm not on that. But what right you have? beyond the leasehold right.
Because I have a
You
right.
may at best, your right would be at best to the extent of what you can enter from that person concerned, file a proceedings before the DRT, not here.
Sitting, we may invoke that is a separate aspect, but.
But
the
you cannot
mortgage
do it
itself
here.
will-
Nothing doing you. How
the-
can you do it? Yes, Mr. B. Gogoi. Try to help the petitioner.
My lord, lordship will kindly turn to page 91. There is some collateral security being given, my lord. These are land documents, details of land.
Yes.
Authorities, my lord, they can very well, my lord, proceed against this particular property.
That we have already proceeded with. That is indicated in the 13.2 and 13.4 that we have placed on record.
Then
So that is his residential property. That also we are proceeding against that. We are not letting him go or anything like that. But the question remains, my lord, once the security is diluted, do we get nothing, my lord, out of this ship? Because here is
your right is what right you have. Can you show me any provision of law by which you have a right or any judgment to that effect? What is the scope of a leasehold right?
my lord, the section 73 of the transfer property.
No. This is another aspect of the matter. So, transfer of property act context. What is the area of a interest created on a leasehold property?
Yes, well, I also rely on two judgments, my lord, of other high courts, my lordship would kindly consider.
Supreme Court?
No, Supreme Court I couldn't find.
No.
I could not lay my hands on. No, this is not a very everyday topic, my lord. We do not find so many judgments.
But this is every day happening.
Lordship will lay down.
What does it say? In Madhya Pradesh, what does it
Madhya
say?
Pradesh, my lord, the issue was whether, my lord, the charge of the
Therefore,
state.
consider whether a charge of a bank on a leasehold plot of land mortgaged as security.
But if I may take your lordship to, my lord's, para 18 onwards, my lords, para 18. Seventh page, para 18.
How does this judgment help you in Madhya Pradesh?
Well, here the charge of the bank was held to be prior to that any claim by the state. This property belonged to the state, my lord. This was also allotted to a particular lessee, my lord. Lessee mortgaged it. And then, my lords, when the time came, my lords, to sell the bank had auctioned that property. And here, my lord, the question was whether any claim by the state would take preference over the claim of the bank. The court has held that priority would be given to the claim of the bank, even though it was a mortgagee only of the leasehold bank.
The other one,
The other one, my lords, is a case of acquisition of land under 73(2) of the TPA.
How is 73 helping you?
73 would help me, my lord, because here, my lord, I am a mortgagee, my lord, who is not in default. And here the property has been sold to recover the charges of a public nature. And
Huh?
since the 73 represents substituted security, where the original property is lost. Now, my lord, my interest in the leasehold property, the mortgage, my lord, that has been completely lost because now, my lord, I cannot even exercise any right under the lease deed also, which was there under the lessee. So since, my lord, the mortgagee has lost the power, my lord, over the mortgage property as such, substituted security, my lord, says
No,
that
you see, they took up the action against whom?
against the plantation,
Against ATCL.
against ATCL because ATCL is the owner.
Understood?
Yes.
They took the action against ATCL for not payment.
Yes.
Because it could not, such a huge amount could not have been with, they being given only for 1 year. Because you took the action in 2020, the lease was action in 2023.
Yes.
Maybe that respondent number 7 may have come up and said that I'm going to pay. And therefore you permitted him through the district administration to run. And thereupon it was given and they entered into a lease on the basis thereof. This must have been the arrangement, how it is worked. But a payment has to be made on account from them.
Yes.
But if that amount, can only recover the amount to which they are entitled to. So they have the first charge,
Yes.
being the year, so they get.
Yes.
The second is the amount, remaining amount to which he has to get it. Okay.
Yeah.
What privity of contract you have with him? No.
The privity of contract here, my lord, the privity of contract arises that the money was deposited directly in the account.
That is immaterial. That is another action which has nothing to do. Your contract is only with 7.
Yes. Mine-
7 could not do it. So your action has to be taken from him. He is leasehold right. In fact, it is, I would have understood if they had taken any action against that person, that couldn't have happened because that is only for 1 year. And he may have given the undertaking that yes, within 1 year, I am going to pay all this amount, the defaulting provident fund, and also take the loan from you and have taken the loan, given the money to them.
Yes.
You made the direct transfer to them.
Yes.
These are all immaterial aspects for the purpose of these proceedings.
Well, as far as we are concerned and as far as the relationship between ATCL and us are concerned, that is the only part of that. The money was from the term loan, the entire 2 crore 40 lakhs went to their account. They made, because the CC account, the balance, my lord, that has been paid, released directly to the respondent number 7. Because CC account is used to run a business. So he gets it to run the.
That is another thing. You see, the main question is how much money on account, because the contract is between you and 7.
Now, if your lordship would say that is there any separate agreement between us and ATCL? No, there is none, my lord. But the mortgage was created with the permission of ATCL, my lord.
Understood, permission
With
is
the
there,
consent.
but can you have a right over the ATCL property
ATCL
to
property.
get
my
a
lord,
share of the out of the sale proceeds? No.
Because my lord, the leasehold right is over ATCL's property. ATCL also could have paid off, my lord, the PF dues. It is not that, my lord, big an amount.
Huh?
The amount of PF dues for 1 year, my lord, that has accumulated. My lord, they also received a lease premium. They have also received a lease premium. My lord, ATCL being the owner of the plantation could have, my lord, paid that dues and recovered it also from the lessee. Now, my lord, the fact remains that the plantation is now sold by PF. Third party right is paid. There is nothing, my lord, that we as a mortgagee can do as far as the plantation is concerned, because that reallotment right under the lease deed, that stands completely extinguished. We cannot exercise, we cannot even ask ATCL that you allot it to any other person of who may be successful because of the auction. So here there is an intervening event, my lord, which has extinguished completely the leasehold right in the mortgage. So our security interest that was created.
Now let us take an example where Provident Fund is not in the picture. Let us take. ATCL is there, respond number 7 is there, and you are there. ATCL, respond number 7 defaults. Can you exercise 13(4) and sell off that property?
No, we cannot sell.
So
We
why
can only
not?
sell, we can only sell the leasehold right, nothing else for the balance.
So it is only that the amount of which you can get out of that leasehold right, that is it. And you made a mistake of whatever you are assessing. Forget about them.
No, the fact remains that when the auction has now taken place, the plantation has been sold, everything has been sold as a going concern. Now the leasehold right for 30 years was also over.
Understood.
Factory and all.
I understand that, yes. The thing is, the problem with that of the PNB, I understand. But the problem is, how could you have taken a lease on that and paid so much of money? You should have understood that this is the state of affairs. What is your right in respect to a leasehold right?
The money that is so is not only calculated on the basis of the valuation of the property.
Because you see, 73(2) is it, you are a mortgager, it's okay. What does it actually say? You see, if it's the mortgager, the mortgagee has paid certain amount of the money out there, then tomorrow if the land is acquired, the mortgagee has the right to get that amount to which he has paid.
I'm not under 73(2), I'm under 73(1).
Let's see what 73(1) says. And that judgment is of 73(1)(2).
No, I'm because 73(2) follows from 1 only, because it's a.
Let us see what the 73 say.
73(1). If I may read, where the mortgage property or any part thereof or any interest therein is sold owing to failure to pay arrears of revenue or other charges of a public nature or rent due in respect of such property, and such failure did not arise from any default of the mortgagee, the mortgagee shall be entitled to claim payment of the mortgage money in whole or in part out of any surplus of the sale proceeds remaining after payment of the arrears and of all charges and deductions directed by law.
So what is the mortgage property here?
Mortgage property, my lord, here is the leasehold right for.
Leasehold rights. It is not the property. It is neither the lands, neither the buildings. No.
The right
These
to
are
use
not.
that.
It is the right of a leasehold right.
Yes, the right to use the factory, machinery, plant, tea booths,
Yes.
trees, everything.
Very well. Only that right is being mortgaged.
Yes, that is why, my lord, the 73(1) says any right therein, my lord.
No, no.
Any right, my lord, would include.
Yes, you can't bring everything out there unless that part is not a part. You see, mortgage property or any part thereof
Or any
or
interest.
any interest therein.
Look, this interest, my lord, is a saleable interest. My lord. Lordships are aware of the concept of saleable interest, my lord, in the Income Tax Act, for instance. Any right, my lord, the legislature has not used the words in a vacuum, my lord. When the mortgage property or any part thereof or any interest, my lord, what does it mean? The legislature.
Mortgage part, just for example,
No,
the
or any
no,
interest.
let us the A is the mortgage property.
Gotcha.
A part of A1 is the part.
Gotcha.
So that must have been.
Or any interest therein.
So any interest in respect to that, it will be only a leasehold right.
Yes.
At best, it is a leasehold, but how do you quantify that? On the basis of whatever money you pay? That is your the thing which you have done. You have paid so for 2 lakh or 4 crores or 5 crores on that.
If that be so, perhaps, my lord, if not entirely, at least the amount that was paid as by way of a term loan directly to ATCL, that, my lord, would amount to any interest therein, because otherwise the words any interest therein would be redundant.
No, the ATCL question does not arise. The term loan, the ATCL has no business with you. ATCL has no business with you. Your business is with 7.
Yes. Then, my lords, or any interest therein, my lord. These words cannot be rendered redundant, my lords. These words definitely mean, my lord, words, my lord, including a leasehold right. So, my lord, now in this case, the leasehold right has been extinguished. Now, by the
leasehold rights over a property belonging to somebody else.
Yes, but, my lord, this property, it is that property which has been sold, my lord. That leasehold right was over.
How do you quantify the leasehold rights? Tell me.
That part would.
How do you quantify the leasehold rights in respect of a property which have been given for 30 years, where the owner still remains?
In that case, my lord, we have to go by the quantification that is there in the lease deed, my lord.
Who has done it?
No, we have not done it. It is ATCL who has done it.
Okay, what is the quantification?
But for that, my lord, we'll have to go to the.
Let us see there. What is the quantification? In this case, the net present value of the total lease consideration for the Sipsagar packet comes to 24 crores. As specified in 1.5.2.2 of the RPF, so and so. Quantification.
Sipsagar packet refers to both the gardens, Rajabari and Dipling.
Huh?
Sipsagar packet here means both the gardens, Rajabari and Dipling both.
You should have objected such less amount being sold. But anyway, you have not. Yes, Mr. B. Gogoi. Let us not only grill Mr. A. Ganguly. What is your case?
Well, so far as our part is concerned, my lord, we have already leased out that property to three states, to the my lord, respondent number 7. He took a loan from my lord, the present petitioner. Now, whatever my lord, transaction was there is between respondent 7 and the petitioner here. And if any amount has been deposited to us, it is as per direction of respondent number 7. He has got some liability, so he has paid to the ATCL. Maybe by way of a bank loan. For that, my lord, we cannot be hold responsible for repaying it or something of that sort, madam. And so far as the present claim made by in the present petition is concerned, madam, it is a right, madam, that they are trying to project that it has accrued from some agreement that they were entered into with the respondent number 7. And in lead proceeding, probably, madam, that right we cannot assert, madam. It cannot be determined in the present proceeding. That's my understanding, madam. Not be the proper forum to decide that part.
Where?
In the lead proceeding. If at all. Because the entire liability.
Yes, madam. What do you say?
We are not in the picture.
So you are a counsel sitting out here.
Even assuming 73 is, he wants to enforce his security. He can't come to 226 and enforce it. He has to then go through and then stand in queue and decide who gets what of the surplus. What I have that could be of assistance and he will know better. We got a letter from Assam Tea Corporation, which says that the two gardens, apparently respondent number 7 owes ATC 4.82 crores, and this is in relation to workers and employees and rentals. So total is 6 crores. Provident fund dues are 2.08, balance will be 3.95. Of this 3.95 will be the balance, but regarding this will be both tea estates. R7 owes 4.8 crores. So there will really not be any surplus.
No surplus. Nobody gets anybody.
No, no surplus for secured creditors.
Lordship, that is.
No,
the
after
status of
giving
affairs.
it to him.
Yes, your Lordship.
No, because
Your
the
Lordship,
workers will have
Yes.
prior.
That is. And Lordship, he didn't, there's no challenge to valuation. This is the second round of litigation. The first time challenge, auction went on, there were no buyers. So the value is what it is. We're not getting any more valuers. There's only a provident fund accruing.
Who challenged they? PNB.
The first auction that this is the second round. The first auction, they challenged. We were allowed to go ahead with it. We went ahead with it. We have no buyers. So it lapsed. Then this is the second round. So at 6 crores also, this is the second round that we've got a buyer. And we've got a buyer for one tea estate, not for the other.
Mm.
I'm just trying to impress upon your Lordship that valuation is not unrealistic.
No, that is another thing.
Yes,
Is he asking for that?
Your Lordship.
Is he
But this-
challenging the auction? So then that
He is
goes.
waiting for balance amount. But that fight, he has to do response number 7. He made a bad business call in valuing a property, that is his leasehold interest, and giving 6 crores. Unfortunately, leasehold interest today is of no value. That is.
And what is this? Page 189, Punjab National Bank, property belongs to Punjab National Bank. What? How?
That's a banner.
So that Lordship, they have pressed it.
Yes.
Done by,
There, after we got
we are
an
not
order
claiming
from-
at that moment. Whatever we have claimed in pleadings, that will stand, my lord, not the banner.
Considering they have gone to.
Anyways, madam, I think you bring on record that aspect by way of an affidavit. These details.
This letter.
Yes. Now these details, which you are saying, that there is no surplus.
Yes, your Lordship. This is actually not, this is a letter given, they're in a better
That I will,
position to
I will
say.
file for that.
Yes,
Or
he should-
affidavit being
he
given.
Means who are the person? Because you see, anyway, whatever may be, if they get any certain amount, but if their workers come into this thing, their footing is on a lesser wing. They can't. Because the workers or the Provident Fund authorities, they get a better year as per the schedule. That is as per IBC. What is that provision? IBC is there.
Companies Act also and IBC also.
Huh?
In Companies Act also and IBC also.
Companies Act also,
Right.
they have, yes, that's fine. That I know. IBC is also there,
IBC.
where there is a.
IBC, they call it waterfall mechanism. Waterfall mechanism.
So as per that, just bring on record that aspect by way of an affidavit.
Right.
We'll look into it. But the point is interesting because why I'm saying so, it requires some judgment, more particularly in Assam, taking into account that there are a lot of these banks which are giving loans on these leasehold plans. And this has a lot of,
Yeah.
I understood it because I saw some, when I was a lawyer, I could find some of the properties in houses. A lease is being taken out there or some property lease has been taken for 10 years, they are giving on lease. But at the end of the day, the bank cannot enforce more than what it is.
Yes.
They may give whatever a loan and this keeps happening out there. So I think
Yes.
some judgment on this point would be required. Otherwise, it will have a. But the problem is doing it in a judgment of this type, and then it may have create a havoc with others.
Well, it has to, that law has to come. It has to be laid down. Lordship will lay down, my lord, that then it will not set it. Because otherwise it may, either way it will set some sort of precedent. Let it be.
Because
Let it be. a precedent.
Banks like PNB.
No,
Let
they
it
are
be a
no,
precedent
I don't know,
banks
my lord,
like
why they are
PNB
adverse to
because-
our interests. We are not
No, I'm
opposing, I mean.
not, but
We will take the bad call.
Not on that. Banks like PNB, it is not a question of banks of PNB. There are a lot of other banks also. Madam, actually, I'm telling you, many banks. Now, the public, but no, private sector too, they would get the money from you. Well, however, whatever crook hook or crook, they will get you the money. That they know it. There's no problem. Anyways, you bring on record that aspect. Then we may take a call as to whether to go on the merits to that spec or else. Yes, we fix it when. Let's have it on a file and finish it off. Let's have it on 26th of September. the matter, this court has heard Mr. A. Ganguly, the learned counsel for the petitioner at length, and Ms. G. Goswami, the learned counsel appearing on behalf of the Provident Fund authorities, and Mr. B. Gogoi, the learned counsel appearing on behalf of the state authorities, including the Assam Tea, Assam Tea Corporation,
Limited.
Assam Tea Corporation Limited. Commerce, Industry and Commerce. When so appears, during the course of the hearing, Ms. G. Goswami submitted that there is in fact no surplus,
Intimated by ATC.
as have been intimated to the Provident Fund authorities by the ATCL, and in that regard have mentioned about certain figures. This court is of the opinion that the said aspect is required to be brought on record by way of an affidavit. List this matter again on 26th of September 2024. No, 24th. 24th of September 2024. Full stop. The affidavit be filed on or before 29/2024 by the respondent number 2. I'll have a look at it, what can be done, because this is a very difficult thing if you are doing. You'll have far-reaching consequences. Leasehold right, how can you do it?
Doctor, we'll also file an affidavit bringing on record how many.
Do whatever you like.
Item 20.
Mr. Talukdar, what do you have to say? I think we can remand it. And I would not discuss into all these other nitty-gritties about what you said about the, what do you call, that it is exercise under 45, he says about 27. Let us not go into this. We go on a simple aspect that he has passed the order on the basis of this, that acceptance, that voters list. This is a case where all these petitioners were elected uncontested. And as such, as they have been elected uncontested, the private and observers report categorically says 2,300 is the total shareholding. Now, if there is 2,300 and 359 persons have yeah, how much, whether it would have materially affected this aspect of the matter have not been taken into consideration. And accordingly, direct the register, because this order it seems to be passed without proper application.
Pass an order, but Lordship will kindly record my submission. My submission is, under the scheme, my lord, the register is empowered either to approve or disapprove. Now, Rule 32 says that only after approval of the EJM/election, my lord, they can constitute the board. Now, once, my lord, the proceedings of the meeting, the AGM, is disapproved, my lord, as a corollary, the election goes. This is under the scheme, unlike, my lord, the
Mr.
election.
Talukdar, I'm not recording his all these other submissions. Why should I make it flow?
What I'm trying to say,
I understand what you are trying to
because
say.
your lordship will kindly say,
You have, you see, the reason why it was disapproved. Let us go by the basic. The reason it was disapproved is on the ground that the voters list, there are some people who are dead and some people who are alive, and there has been double voting. Double shown it has been. You say that it is a case of quorum.
No, no, my lord, no.
It is a
My lord,
question, it has to be
my
a
lord,
case of
I
quorum.
submitted impromptu, my lord, your lordship will see from 102, it does not appear that while passing this order, the registrar had considered, my lord, the issue of quorum. Because what the registrar said. my lord,
Then how does it help?
Absolutely. But what I'm trying to say, register, my lord, whether or not the register is entitled to consider that when, my lord, the proceedings of the AGM is tainted with irregularity, illegalities, my lord. and
You
such-
cannot just say
No,
illegality,
No, my lord,
irregularity.
no, lordship
What
will
is
kindly
this
see,
illegality?
This part of the findings
It
is
is,
not under challenge.
it is a case out here where there is a person concerned has the register has not, he has put a valid argument to that effect. That how is it irrelevant in my election to as regards or the AGM? When this election was held in total, yes, I understand. Your submission is that AGM election is not the only thing. There is an AGM altogether. And the AGM having been held in this manner should not have been.
And my
But you, for that,
my lord,
for
even
that,
either your
where,
lordship will
where
see,
is it finding to that
Even
effect?
either
On perusal
approve-
of the attendance sheet. Where is that particular document? Yes.
102,
Further,
my
it is found that no application process for Aisha Sultana is which order?
No, 102, my lord. If your lordship comes to the 102, the imping order,
Yeah.
the last part, my lord.
Heard the
penalty.
petitioner and respondents and on perusal of the attendance sheet of the AGM held on so and so, it is found that many shareholders has signed the attendance sheet twice and signatures have been found against the share numbers of dead voters.
What I'm trying to say, my lord will kindly appreciate my argument. My lord, rightly or wrongly, your lordship may reject it. My lord, being a my lord, authority, supervisory authority, my lord, the register is empowered, my lord, to disapprove on this ground itself, irrespective of, my lord, an effect on the election in AGM. Having found, my
Have you
lord,
filed an affidavit?
no, my lord,
No. We have asked you to file an affidavit. You have not. Then why did you explain this aspect of the matter?
Explain, my lord.
No,
Your
you have
lordship
not filed an
It's
affidavit.
apparent on the face of
We
the
put
record.
that down on that we have given you the opportunity, then also you didn't file the affidavit. And that is the reason, and as such, now they cannot. We then
No, my
approve
lord,
it.
I am not adding words, my lord, what the
I am
register
adding,
has said.
there's nothing to add with words.
Yes, absolutely.
How
I'm pointing it out.
can tomorrow the register come up and say, then look here, that this is bad. On the ground that the attendance, there are double voting and all these things he has stated all this thing. Or there is what he say, many shareholders have signed the attendance sheet twice and signatures have been found. He had challenged this aspect.
Paragraph
No,
13,
no,
page
no,
14.
these findings is not
Paragraph
under
13,
challenge,
page
my lord.
14. I stand by the record, my lord. Paragraph 13, page 14 of the writ petition. I've taken a stand, doctrine of non-traverse by all.
Yes. On the doctrine of non-traverse, then I
Doctrine
think
of non-traverse.
we said we don't remand
My
it
lord,
back.
no, my lord will kindly say.
No, because this is a case where we have been given an opportunity to file your affidavit, you have not filed. On the
My
basis
lord will
thereof.
kindly say, lordship may pass order, but your lordship will kindly see there is no, my lord, aberrament in the writ petition saying that these findings is perverse and not based on record. That there are no my lord, there are no, my lord, fictitious signatures. There is no, my lord, aberrament to that effect. There is no such pleading, my lord. In respect of these findings, my lord, there is no challenge. They have not stated that this particular findings is perverse and it is not based on record. There is no such pleadings, my lord, in the writ petition. So my lord, the question of non-traversal, my lord, does not come in so far as this part is concerned.
Error
13, page 14.
stated by total. Firstly, the complainant dated so and so is not maintainable as it offends to him.
The
Secondly, a bare perusal of the orders who demonstrated the did not indicate as to how many shareholders and who had signed the attendance sheet twice and how many of these were found to be. This demonstrates a attitude and a total non-application of mind by the jurisdiction, and the same invariably vitiates the decision making and renders the decision bad in law. Thirdly, the correction of the iman of the so-and-so after correction being so affected, the approval of the number of voters in the voters list by the iman, the issuance of the notice for the AGM for filing of so-and-so of the 14 numbers of uncontested candidates were never challenged as a matter, and the return had nothing to do with the voters list, which is purely Then where is your reply of application of mine? Where is your records to show? You produce the records. Then
No, well, what I'm trying to say.
You
not
don't
even-
come up with
well,
all
not
these
even
things.
pass any order. What I'm trying to say,
No,
this part.
No,
saying that-
remain, enough. This is a matter we have heard many times. Heard Mr. S. Bonik, the learned counsel appearing on behalf of the petitioner. Mr. S. K. Taluk, the learned appears on behalf of the Corporation Department of the Government of Assam, as well as also the officials under the Assam Cooperative Societies Act 2007. Mr. Ms. Peever, as per the learned counsel appears on behalf of the private respondent number 6. The instant writ petition has been filed by the petitioners. And again, 14 writ petitioners. 14 na? 14 writ petitioners who have been elected uncontested in the AGM, annual general meeting oblique election of Meherpur Krishnapur CS Limited, held on 18/8/2023. Held on 18/8/2023, have approached this court by filing the instant writ petition challenging the order dated 21/9/2023. The brief facts leading to the challenge are that the board of directors of Meherpur Krishnapur Cooperative Society Limited, for short, the Cooperative Society, was dissolved on account of not holding the AGM oblique election within the statutory period. And a one-man committee was appointed by the jurisdictional authority by order dated 17/12/2022 for managing the affairs of the cooperative society, as also for holding the AGM of the election within 90 days, so as to constitute the new managing committee. Before further proceeding, this court finds it very pertinent to take note of that in view of section 41(6) of the Act of 2007, a responsibility is cast upon the officer of the cooperative department for constitution of a board within 90 days from the date of such appointment. This aspect of the matter is pertinent in view of the fact that with the dissolution of the board, the entire responsibility, therefore, is in the shoulder of the one-man committee so appointed by the Department of Corporation. Next, proceeding further, it is seen that under the aegis of the one-man committee, a voters list was prepared. On 26/12/2022. Thereupon, a notice was issued on 11/1/2023 in terms with section 26(3), isn't it?
No, sir.
Of the Act of 2007. Notifying the names of dead persons in the draft voters list, which would be corrected by substituting the names of the legal heirs, and that applications to that effect be submitted before the said secretary from 14/1/2023 to 31/1/2023. Consequent upon publication of the said notice dated 11/1/2023, 13 candidates applied for substitution of the names against dead shareholders. And a correction was duly effected, and the final voters list was published on 8/2/2023 by the one-man committee. It is pertinent to mention that this final voters list was approved and countersigned by the Zonal Joint Register of Cooperative Society Silchar, Zone, Silchar. A resolution thereupon on 8/2/2023 was adopted, whereby it was made clear that 2081 voters from weaker section and 218 voters from the, what is that? From the, what is this? So see, where's the resolution?
Resolution, your lordship will find at page 54, madam. The particular. Of the
No, the English one?
English one, it is, my lord.
Huh?
Before that, no.
No, not the 18(3).
Oh,
That resolution,
sorry.
which is there, Annexure C.
C is at the notice.
Now, where is that? What have you mentioned at paragraph 4?
When two weaker section, one should be stronger section. It
Huh?
should be stronger section. One will be stronger section. I stand corrected.
2081 stronger voters.
20 voters, stronger voters.
Stronger or weaker?
20 stronger weak. 218 weaker.
Yeah. 1
I'll stand corrected. It will be 218 stronger.
Huh?
218 stronger.
A resolution was adopted on 8/2/2023, whereby it was made clear that 2081 voters were from the weaker section and 218 voters were from the stronger section, were eligible to cast vote. Thereupon, the final voters list was published on 8/2/2023, which was, however, not challenged as stated by the petitioners. Subsequent thereto, the Secretary of the Society of the Cooperative Society issued a notice dated 23/2/2023, whereby it was notified that the date for submission of the notification nominations was 1/3/2023, and the date for withdrawing of the nomination was up to 3/3/2023. It was also mentioned that the date for AGM oblique election was on 11/3/2023. At this stage, it is very pertinent to mention that the respondent number 6, along with 10 others, on 9/3/2023, addressed a complaint to the Minister for Corporation. A perusal of the complaint, which have been enclosed as Annexure E to the writ petition, mentions that alleges that the ex-chairman of the society had been running the society without following statutory government guidelines and rules. And the chairman and his associates, ex-chairman and his associates, have been involved in malpractices and corruption in respect to the management of the society. It has also been mentioned that the ex-chairman circulated a notice for general meeting of the society proposed to be held on 11/3/2023. It was also stated that the decision of the election taken by the ex-chairman is not taken as per the Act of 2007. It was also alleged that 40% of the members of the cooperative society have already expired and the voters list have not been prepared. And without preparing new voters list, the election would not be free and fair. Under such circumstances, the respondent number 6, along with 10 others, requested that the elections be postponed until a new voters list is prepared. At this stage, this court finds it very pertinent to observe that from a perusal of the said representation submitted to the Minister of the Corporation, it reveals that the respondent number 6, along with 10 others, seem to have been unaware of the notice dated 11/1/2023 and the final voters list dated 8/2/2023 being issued at the having been published. It further reveals that the respondent number 6, along with 10 others, were unaware that it was the one-man committee who had decided to hold the election as it is in terms with section 41(6) of the Act of 2007. It is not known as to what transpired from the said representation. What actions were taken on the said representation by the Minister of Corporation. However, in terms with the notice for the elections, for holding the AGM as well as the elections, 17 candidates submitted nominations before the Secretary of the Society. No, submitted nominations before the returning officer. Before the returning officer who was duly appointed by the Corporation Department. Out of the 17 candidates who submitted the nominations, one candidate withdrew and nomination of 2 candidates were rejected. Under such circumstances, there were only 14 valid nominations. It is further relevant to take note of that the total shareholding of the shareholders of the society who are eligible to vote are 2,200 and 2,299. But I am imposing a cost upon you, of 1 lakh for the number of mistakes you have done. Upon you as Bonik, not the petitioner. Yes. Everywhere there is a mistake. 1 lakh to be deposited in the registry. How many times? Everywhere there is a mistake. Look here. How many mistakes? Paragraph 4, see, weaker section, stronger section, wrong. Time of resolution, 8/2/2033, which is yet to happen. Huh? Then total number of shareholders on one hand is 218 and 2081. Total is 2,299. You have put 2,229 on the ground of this 1 lakh. Okay. At this stage, it is relevant to mention that the total number of shareholders of the society is 2,299. However, on the date of the AGM, public election, the quorum was not achieved. And accordingly, the elections were adjourned to 18/3/2023. On which date, as per the petitioners, 359 shareholders were present at the meeting. Taking into account that 14 candidates were vying for 15 posts of the board of directors, the returning officer, by exercising the power in terms which Rule 13A, 13A,
Yes, correct, 13, my lord.
Rule 13A,
Yes.
13A, na?
13A, my lord, yes.
13A
No election.
of the Assam Cooperative Societies Election Rules 2019 declared the petitioners as duly elected. Full stop. It is, however, it is very pertinent to observe, taking into account the dispute involved, that apart from the returning officer who was duly appointed by the register of register of cooperative society, two observers were also appointed. These two observers, pursuant to the election being held, submitted an observation report to the Assistant Register of Cooperative Society, Silchar, on 18/3/2023, stating inter alia that the adjourned AGM/election was held on 18/3/2023 at 10 a.m. and 359 numbers of shareholders were present and signed in the AGM proceedings books as per the office record book, full stop. As per the office record, total eligible shareholders were 2299 and the required quorum was 230. Full stop. On 3/4/2023, the Register of Cooperative Society passed an order thereby disapproving the AGM the election on the basis of the complaint filed by the respondent number 6 and 10 others before the Minister of Corporation. That is it. Before the Ministry of Corporation.
That was forwarded to the register.
Whatever may be, that is it. Is that the manner?
No, I leave it to us.
This court inquired with Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner, a respondent department, as to whether the complaint referred to in the order dated 3/4/2023 is the complaint which was submitted to the Minister of Corporation Department. The learned counsel submitted that the said representation which was submitted were forwarded by the minister concerned to the Register of Cooperative Society. It is the case of the petitioner that the petitioners were never heard during the proceedings, which led to the order dated 3/4/2023. And this aspect of the matter seems to be an accurate statement in view of the fact that in the order dated 3/4/2023, it has been mentioned as to who were the persons who were present in the hearing on 28/3/2023. This court at this stage would like to take note of Section 45 of the Act of 2007, which stipulates that any general or a special meeting of the board has to be approved by the register within a period of 15 days from the date of receipt of the said from the date of within 15 days from the date of receipt of the proceedings. And it further mandates that if no approval is received within the said period, the proceedings shall be deemed to have been approved. It is not known as to whether when the petitioner register of cooperative society had received the proceedings. However, it is clear from the observer's report dated 18/3/2023 that the same was duly addressed on 18/3/2023 and sent to the Assistant Register of Cooperative Societies. This aspect assumes importance taking into account that as on the date of passing of the order dated 3/4/2023, the period of 15 days is over. The learned counsel appearing on behalf of the Corporation Department, however, submits that the register was in session of the matter as a hearing was conducted on 28/3/2023. But the said submission does not impress this court, taking into consideration that the Section 45 does not grant an exception to the said aspect. Even otherwise, the petitioners were not heard on 28/3/2023, as is apparent from the order dated 3/4/2023 itself. Next. The petitioners, being aggrieved, approached this court by filing a writ petition which was registered and numbered as WPC number 2052/2023. This court, taking into account that a perusal of the order dated 3/4/2023 did not show that the petitioners herein were at all heard, set aside the said order dated 3/4/2023 and directed the Register of Cooperative Society to take a decision in respect to the complaint so filed by the respondent number 6 within a period of 1 month from the date of the said order by giving the parties, including the petitioners herein, an opportunity of hearing. This order was passed on 19/7/2023. It is further seen that pursuant to the said order passed by this court on 7/9/2023, the petitioners have submitted a detailed representation to the Register of Cooperative Society to dismiss the complaint dated 9/3/2023 and to approve the proceedings dated 18/3/2023 of the AGM oblique the election of the Cooperative Society and allow them to form a new executive committee to manage the affairs of the society. Thereupon, the order, impugn order, was passed on 21/9/2023, which have been assailed in the instant proceedings. In the backdrop of the above facts, let this court take note of the submissions made by the learned counsels for the parties. Mr. S. Bonig, the learned counsel appearing on behalf of the party, petitioner submitted that this is a case where the Register of Cooperative Society have taken a decision not to approve the AGM oblique the election of the petitioner of the society for vested reasons, for vested reasons. He submitted so on the basis that the Register of Cooperative Society had not at all applied its mind and perfunctorily exercised his jurisdiction drawing reference to the complaint dated 9/3/2023 submitted by the respondent number 6 along with 10 others, and the same being forwarded by the Minister of the Corporation Department, the learned counsel submitted that the same have prevailed upon the register of the Cooperative Society rather than the facts which was apparent on the records. He further submitted that the voters list was prepared in terms with by the one-man committee who have been appointed by the Corporation Department. Objections were filed, objections were called for, and only 13 persons have filed their objections, and thereupon on 8/2/2023, the final voters list was published, which was approved by the Journal Register of Cooperative Society. In the said approved list, which was published on 8/2/2023, there were total 2,299 eligible voters. The respondent number 6, along with 10 others, seem to have been entirely unaware of the said process or did not want to mention the same before the minister in the representation. The learned counsel submitted that a perusal of the representation also shows that it was absolutely a vague representation and have been only filed to stall the election proceedings which was to be held on 11/3/2023. In addition to that, the respondent number 6, could have very well participated in the said proceeding, but she did not.
Lordship, may I point out, Lordship, she participated, may I point out?
He submitted. I'll put yours. He therefore submitted that the power which has been conferred upon the respondent number, upon the register of cooperative society, is not a power to be exercised in the manner in which it has been done. In addition to that, the Learned Counsel further submitted that in paragraph number 13 of the writ petition, it has been categorically mentioned that the ground on which the impugned order was passed is without total application of mind, in as much as there is no materials on, there is nothing mentioned in the said order as to how many persons who have twice signed the attendance register and how the elections have been affected. In further continuing with the learned submissions by the learned, further continuing with his submissions, the Learned Counsel submits that a perusal of section 41 of the Act of 2007 would show that the elections of the directors are to be held in a general meeting called for the purpose. The Learned Counsel submits that though an AGM is a general meeting, but a conjoint reading of section 32 with 39 would show the difference between the two. He therefore submitted that unless and until the Register of Cooperative Society have stated how it affected with necessary particulars, the affected the election with necessary particulars, more so in a case where all the petitioners have been elected uncontested, the impugned order suffers from total non-application of mind. I think more than that I said. Anything more? Mr. S.K. Talukdar, the Learned Counsel, appearing on behalf of the Corporation Department, on the other hand, submitted that an AGM submitted that a perusal of the impugned order would show that what power which have been exercised by the register is a power in terms with section 45 of not approving the general body meeting, the general meeting as well as the AGM, on the ground of the illegalities, which was noticed from a perusal of the attendance sheet. He further submitted that the Registered Cooperative Society found that the voters list of the cooperative society in question was full of anomalies, and as such was justified in passing the impugned order. What else, Mr.? Yes, madam. Now tell me, what do you have to say?
whatever. But only my one concern, before preparing the voter list, mandatory provision of the law has to be followed, Lordship. According to the.
Why didn't you challenge?
Yes, that,
Why didn't you challenge?
so I'll ask Lordship Liberty to challenge it after this. But the 3H, Lordship, even if I don't challenge Lordship will come once to 3H.
No, madam, if you see the facts, and let me tell you, you may be tomorrow on the other side, this side. If you see the facts, this is the register doing at the instance of the minister. Nothing more than that.
But my answer will be Lordship. They are.
My answer, your
Their
answer.
name and Lordship, they went to the minister, and it was forwarded to the.
Why didn't you move the register? Why didn't you file? Why didn't you move? Are you so unaware? I'm not saying about you. Why have you moved the minister?
Even I asked. the
And
same question.
after the minister being moved, then also why didn't you approach the register? What you have done is move the minister. What is this minister business to forward? And
I
minister
understand.
forwards on 9-3 and then you finish everything.
Well, Lordship, that's one part. The main thing, what it has to be recorded, Lordship, or 3H, Lordship. Once Lordship comes to this mandatory provision of law in the rules, 3H. Now, whether I went to the minister or whether I went to the register, that is my fault. But here, when a voter list is prepared, Lordship, this mandatory provision has to be followed, Lordship, because we have said that the voter list was incorrect. So what 3H in the rule says 110.
Madam, listen, you say it to be incorrect very well. It may be incorrect. But when the act mandates in a manner in which you are to do it, it should have been done in that manner.
That is my fault. But Lordship.
That is the
No,
most.
Lordship, but preparing the voter list is not within, it is the domain of the register. What he did, that is why I think she went to the minister because the voter list was prepared under the supervision of the register. Now 3H, Lordship. This is mandatory, even if I complain or not complain, Lordship, this election cannot stand. It is not an election. It was passed in an annual jail break. There was no election held because there's only 15.
Okay,
Lordship,
this 3H.
Lordship, once 3H, Lordship.
As Parveen, the learned counsel appearing on behalf of the respondent number 6 submits that the voters list which was prepared by the one-man committee under the aegis of the register of the cooperative society was a defective voters list. And as such, the respondent number 6 along with 10 others had to approach the Minister of Cooperation Department. She submitted that it is only then due steps were being taken to make due steps is being taken. But however, as the steps were taken at a much later stage, the elections have already happened. She therefore submitted, referring to section 26, read with section of the Act of 2007.
H.
Wait, you can't jump to 3H. 3H is a rule. You are referring to a rule.
I have pointed out.
How do you refer to a rule? First, you have to refer to the Act.
I have pointed out last time, Lordship 26.
Okay, then I put it in your submissions. Later on, when it is reported, people may laugh at you, but let the people laugh. See, when I'm putting it in your submission, let me put it in a proper manner.
Lordship.
She therefore submitted that section 26, the learned counsel submitted that in terms with section 26, the manner in which the voters list is to be prepared have been stipulated. Further to that, she submitted that in terms with section 41, 1, the superintendent's direction and control of the preparation of the electoral rolls is is vested upon the register of the cooperative society. And under such circumstances, the register of cooperative society is required to look into it that the voters list have been prepared properly. And if it is duly prepared, then he would be a shareholder would be an elector in terms with section 3H of the Assam Cooperative Society's Election Rules 2019. The Land Council submitted that in the instant case, 40% of the shareholders have already expired, but there was no steps taken for making rectification of the voters list. And as such, with the defective voters list, the AGM as well as the election was held, and as such, right, the register of cooperative society was justified in setting it, not approving, in disapproving the AGM oblique election held on 18/3/2023 by the impugned order.
Lordship, this may also be regarding this, the dead voters in consultation with the register of births and deaths. That's a procedure, Lordship, for preparing the voter list. Because there's a mandatory provision. They have to consult the register of death and birth. Then they prepare their voter list. Which is never, they also never stated that it was done.
I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration to their respective submissions. From the materials on record, it transpires that even after due opportunity being given to the register of cooperative society to file the affidavit, to the corporation department to file the affidavit, no affidavit was filed. On the earlier occasion, when this court had asked the council appearing on behalf of the corporation department to file the affidavit as to whether they would like to file the affidavit, the submission was that they would argue on the law, on the basis of the facts which are already there on record. Taking into account the said backdrop, let this court therefore take note of the submissions which have been made. In the order dated 21/9/2023, the Register of Cooperative Society have negated the elections, oblique the AGM, held on 18/3/2023 on the basis of that many shareholders have signed the attendance sheet twice and the signatures have been found against the shareholder numbers of dead voters. There is nothing mentioned in the said order as to how many duplicate signatures were there in the attendance sheet and how many voters and how many signatures were there against the shares of dead voters. These aspects are essential, taking into account that the Register of Cooperative Society, while passing the said order, was exercising a quasi-judicial authority. The above, during the course of the instant writ proceedings, the Register of Cooperative Society neither had filed any affidavit in that regard, nor produced the records which should substantiate the basis on which the order dated 21/9/2023 was passed. It is also seen that another reason have been assigned that the voters list of the cooperative society was full of anomalies. However, there is no basis as to how such anomalies has accrued upon the voters list. More so when the said voters list have been prepared by the one-man committee appointed by, who is a departmental officer appointed by the Register of Cooperative Society, and due objections were called, and thereupon on 8/2/2023, the Journal Register of Cooperative Society have approved the voters list. When so many authorities have duly passed such, taken the pains to make the voters list, in the opinion of this court, the Register of Cooperative Society cannot brush aside the said voters list merely by stating that the voters list is full of anomalies, without stating in detail as to how how such anomalies had accrued. The above aspects of the matter clearly shows the total non-application of mind. Next. Proceeding further, it would be seen that the basis on which the Register of Cooperative Society have exercised the jurisdiction is on the basis of a complaint filed by the respondent number 6 along with 10 others on 9/3/2023. The said Register of Cooperative, the said complaint, upon being perused, would show that there is a vague statement made that 40% of the shareholders have expired. During the course of the hearing, this court asked the learned counsel appearing on behalf of the respondent number 6, who are the 40% of the shareholders who have expired?
In my affidavit in opposition, I have given only name of 35 against.
40% of shareholders.
But if the.
40% of the
Not
shareholders.
sure because there's.
Don't make that.
I'm not sure, but I have given
No.
examples. Lordship, 1 minute will Lordship will. go to
But
my-
nothing could be shown nothing could be shown about the said allegation. Full stop. This court also takes note of the submission of the learned counsel appearing on behalf of the respondent number 6 to the effect that the voters list ought to have been properly ought to have been made in a proper manner. And as such, the entire election, as well as the AGM, was not in accordance with law. This court duly takes note of Section 26(3) of the Act of 2007, which categorically states as to which voters, which categorically stipulates the manner of challenging the voters list. The manner of challenging a voters list, as stipulated in 26(3), is to file an appeal to the board within 10 days from the date of affixing of the list on the notice board. It is seen that the list was affixed on 8/2/2023. And taking into account that the one-man committee was the person who was representing the board, the application should have been filed before him and not to the Minister of the Corporation Department. Under such circumstances, this court, taking into account the well-settled principle of law that when the statute mandates a particular thing to be done in a particular manner, and then it should be done in such manner or not at all. This court is of the opinion that the said objection so raised to support the order dated 21/9/2023 is totally misconceived. Accordingly, this court is of the opinion that as the order dated 21/9/2023 has been passed in complete non-application of mind and without any basis comma, as it's apparent from the materials which are placed before this court sets aside the order dated 21/9/2023. Next, what else do you want?
That's, that's. all.
Then what happens?
We
You
already
get
declared
approved,
elected.
deemed.
We declare elected deemed.
Unless you don't say anything, I can remand it. Because the voters list is final.
So when remand it, Malad, he'll take a fresh call now. He'll take a fresh call, Malad.
Again, being influenced by the minister.
No,
This is a pure and simple case of a minister's approval. Actually didn't see the representation. Otherwise, judgment would have come on the first day itself. What is this minister doing all this?
Malad will send it because his approval is also necessary. He will
Not
take a
necessary.
call.
Not necessary.
Deemed.
Deemed.
That not deemed, Malad, because
Deemed.
your lordship will see, on that ground, I have said.
What ground, tell me?
No,
Is that,
what you
what, on what other grounds can he look into?
No,
Tell me.
No, that part, approval part, or we will take a fresh call, whether it has affected, Malad, the numbers. as
Why
well.
should I? I gave you a chance. You didn't file your affidavit.
No, I could have produced the record, Malad, but there is no direction to that effect, Malad.
Not necessary. This is
The
your
lordship-
thing.
the lordship
You
said
were, that is not my lookout. It is your thing. Now, Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner, respondents, Corporation Department, that taking into account that this court, that the Corporation Department did not file the affidavit or produce the reports, an opportunity may be given to the respondent, to the register of cooperative society to revisit the order dated 21/9/2023, which have been impugned in the incident proceedings. And if it is found that such objections, that the signing of the affidavit, and if it is found that the duplicate signatures in the attendance sheet and the signatures of the attendance sheet of that person as stated in the affidavit, as stated in the impugned order, materially changes the quorum, only limited there, changes the quorum, then only the register may have a look at the matter. This court is of the opinion that taking into account that say submission, a further opportunity may be given to, is required to be given to the register to peruse as to whether in the attendance sheet, the signatures and as to whether we look into as to whether the signatures are in the attendance sheet of the alleged duplicate signatures in the attendance sheet, as well as alleged signature of that person, if it materially changes the quorum, then the register can decide the same against the petitioner. However, it is made clear that the register can would have no power to set aside, to intermeddle with the voters list. No voters list business. You cannot. Voters list you can't touch. Voters list remains as it is.
41 is there. 41 is there.
What?
Section 41 is there.
For what?
Look, he is the ultimate authority in respect of.
Okay. এই তোরা এখানে গুছাই দিব।
Obliged lordship.
The writ petition stands allowed as.
No, no. No, that I withdraw.
Goods losses now in railway bridge cover. Goods is other part.
Huh?
Goods yard is other part. Now it is a railway new property.
Yeah, okay.
Earlier one paragraph, my lord, may instead of goods yard losses may indicate that part.
Further submitted, it is not for a year. It was submitted. Paragraph 5 of that not only the petitioner, 21. Where is the 21?
Still not 21. That part losses all will be losses vacated. That area losses.
Submitted.
Petitioners occupied
That
losses.
not only the petitioner, all the houses in that area, paragraph 5 below. On the other hand, Mr. K. Gogoi, the learned CGC, appearing on behalf of the respondent, submitted that not only the petitioner, all the
Encroachers of the area.
all the encroachers of the railway land in and around the petitioners houses would be evicted in that regard, and the process has already been initiated. He submitted that on 34/8/2024, the railway authorities have already initiated the process. However, in view of the order passed by this court, the same was stalled. He submitted that the land which would be cleared from the said eviction
That is from top of six
would be
lines.
required for few infrastructural developments of the railways.
My lord, may 6 line from top losses. Is presently.
And that is for the proposed new rail-cum-road overbridge on the Brahmaputra River, and also is required for better water supply project, which is demanded by the occupants of the railway quarters as well as other public. The said, in that regard, he had he further submitted that in view of the proceedings before the first appellate court going on for the last 8 years, the said projects had to be stalled. In that regard, he has placed before this court an instruction issued by the divisional engineer Guwahati NF Railway, which is kept on record and marked with the letter X. 5/6/7/8/8. In the backdrop of the above, let this court consider the submissions of the learned counsel for the petitioner. The learned counsel for the petitioner had submitted that the petitioner had been singled out in carrying out the eviction proceedings. However, from the perusal of the instructions which was placed, the said submission seems to be not accurate. It seems to be misconceived, taking into account that the said railway land along with the nearby vicinity lands wherein there are encroachers would be cleared for the purpose of carrying out the proposed new rail cum road overbridge on the Brahmaputra River, as well as for better water supply project, which is demanded by the occupants of the railway quarters as well as the public.
Just I indicate one thing also, if petitioner occupied area 5 plot of land, not only one was.
That I know. It is also seen from the notice which has been issued, from the notice which was issued to the notices which were issued to Dulal Chandra Roy, that the said person who was the husband of the petitioner, no, husband, no, father-in-law, father-in-law of the petitioner,
Husband of the.
huh?
Husband of the.
Husband,
Husband.
the husband of the petitioner was occupying 5 plots of land.
Was it 5 plots of land?
That is plot number
Lordship 1, 2, get 1 lordship and then
1, 2, bracket cat 1,
lordship.
and 3, 4, and 5, bracket cat 1. That too without any authorization from the railway authorities. The materials on record further show that the land in question are railway lands and has been specifically and nothing on could be shown on records that the lands are not railway lands by the petitioners, either before the first appellate authority or before this court. Consequently, this court finds no reasons for exercising the powers of judicial review in the instant proceedings, and accordingly, the petition stands dismissed.
Standing item 6.
Yeah, agreed by the order of my lord.
A paragraph level.
Page
Heard
80.
Mr. D. Das, the learned senior counsel, appearing on behalf of the petitioner, assisted by Mr. S. Count, the learned counsel, appearing on behalf of the petitioner. Mr. R. Gogoi, the learned counsel, appears on behalf of the Forest Department of the Government of Assam. Also, a paragraph 2 or 3 to lekhi dibo. Agor order 2, 2, 3 lekhi dibo. Mr. R. Gogoi, the learned counsel, appearing on behalf of the Forest Department, submits what has been held from the petitioner is an amount of rupees. How much?
5 lakhs.
No, the amount towards
Mine and Mineral Development, Restoration and Rehabilitation Fund.
towards the fund in terms with section 2L. L, na?
2L is a definition. Section 58 is a
No, section 2L of the Assam Minor Minerals Concession Rules 2013. And as per the mandate of section
58
58
of
of
the Assam Mine and Mineral
the
Concession.
said rules. Pustak. The learned counsel for the Forest Department further submitted that in terms with the impugned, which is the document
Page 80.
86,
80.
in terms with the impugned communication dated 24/10/2017, no amount have been deducted isn't it?
Yes, no one deducted, neither we have received it, Lordship.
No amount have been withheld from the petitioners.
No.
Full stop. It has, Mr. R.R. Gogoi further submits that the petitioner being only a, what is that?
I was a mining permit holder.
Mining permit holder is not required to pay in terms with the impugned communication dated 24/10/2017. Taking into account the above submissions, the learned counsel appearing on behalf of the petitioner also submits that the forest department, it's not a forest department, nah? It is the mindset. You are what
I'm
department?
for the forest department.
Forest department.
I'm for the forest. That this MMDR, this DMD funds, they will be from Mines and Mineral Department, MMDR.
But letter has been issued by the forest department.
Okay.
Letter we have issued.
That taking into the learned counsel for the petitioner submits that the petitioner would be liable only in respect to the 10% towards the, in terms with rule
58.
2L of the rules of 2013, read with section
58.
section of
It's rule 58.
rule 58 of the said rules. And further reiterates that in terms with the impugned communication dated 24/10/2017, the petitioner is not liable to pay any such deposit. This court, having taken note of the submissions and there being a consensus arrived at to the effect that the petitioner is only liable to pay in terms with Rule 2L of the rules of 2002L read with section Rule 58 of the rules of 2013 and not liable in terms with the impugned communication dated 24/10/2017 and there being no deduction made or from the amounts to which the petitioner is entitled in terms with the communication dated 24/10/2017. This court disposes of the instant petition, thereby setting aside the communication dated 24/10/2017 and further declaring that the petitioner is not liable to make payment in terms with the communication dated 24/10/2017. With the above, the instant petition stands disposed.
Pleasure.
Item 7.
Well, here in this case, my lord, government has, department has filed affidavit.
What does he say?
My lord, they said that earlier there was a proposal for making allotment in favor of 26%. 7% has been granted earlier and there has been a proposal has been made to grant.
It has been submitted that the government of Assam has filed, the government, who has filed?
Just deputy commissioner.
The district administration has
Deputy-
filed, district administration of
Circle officer Raha.
of
Raha,
Nagaon.
Raha Revenue Circle.
It has been mentioned, it has been submitted by the learned counsel appearing on behalf of the district administration that the circle officer Roha had filed an affidavit in opposition. However, the same is not on record. List this matter again on 23rd of September 2024. The petitioner, if so advised, would be at liberty to file the reply.
18(9).
What is this?
Land acquisition compensation.
Payment paid. Huh? Refund লিখিব দেই এটা order. None appears on behalf of the petitioner on call. Full stop. This court, by an order dated 14/8/2024, sought for instructions in respect of the acquisition of lands in dark number 272 and 271 and 272. Full stop. Today, Mr. N. Goswami, the learned counsel appearing on behalf of the respondent, district administration has placed an instruction issued by by the additional district commissioner, L.A. Dhemaji, wherein it has been duly mentioned that the land in respect of 8 lessors of land of dark number 272 and 1 lessor of land of dark number 271 have already been acquired by the Railway Authority, and the compensation amount claimed by the petitioner against the said 2 darks have been duly paid as per the office sanction order dated 18/2/2024. The said instruction is kept on record and marked with the letter X. In that view of the matter, the instant writ petition has become infructuous, and accordingly, the writ petition stands disposed accordingly.
And
No, anyway. Yes, what is this?
Well, here Lordship has directed us to obtain it in the file affidavit by order dated 14/8/24.
Directs the additional resident to file an affidavit
Kali para
with respect to the schedule B land and how much of such land is. Yes, you
But,
file affidavit.
We have filed the affidavit, Lord.
Okay.
Malad, the schedule B contains 4 bigha 13 lesser land. Out of 4 bigha 13 lesser, 1 bigha 7 lesser has already been taken out, acquired in the earlier process, and amount has been paid. The remaining amount of 3 bigha 5 lesser, this is the in the additional process. It is being done, Malad. But I have a copy of the affidavit. It would. But that is the later as regard
Area, that an area of land measuring so and so hectares equated in so and so for which an amount of rupees so and so has been assessed by the subject in
logically see the affidavit.
Where serial number?
Serial number is Malad
Tag number is what?
266, page number 5.
266.
Yes.
266. Number 5.
0.4093.
0.4093.
Yes.
Chaos. Stopok chaos. Where is the Debendeka comes?
No, Sapok is the father of Devon.
Huh?
Father of Devon.
Sopok chaos. Oh, you have got, you will get the money.
Yes, my lord.
Then
Okay.
what do you mean?
And as regard the second query, Lordship has another query as to whether the land is under whose possession. The later second paragraph can be seen.
As to how much of the land of the petitioner is under the possession of the respondent.
Lordship.
Now you have taken the possession.
No, although after the notification, after publication of 3A, the land has to be handed over to us, because of petitioners, they are objection, the respondent, they are not in a position to do
When
anything.
3D has been published,
Yes,
then under 3E you enter.
they are objecting to that.
Oh,
And that is.
you
where
have the force, power, police, everything, but you're not doing.
Lots of-
That is wrong submission, my lord. Already they have taken possession, construction was done, therefore I have prayed many times that before your lordship that not to.
But anyway, as of
Already they have
now,
taken, my lord.
no, whatever may be, as of now, this 0.4093 hectares, which commensurate with your earlier some land was taken.
Yes, that.
Okay,
compensation
now
is done.
remaining was 3 bighas, 5 lechas.
Yes.
Now this has been taken.
Yes, my lord.
You will get the compensation of 1 crore 14 lakhs.
My lord, that may be direction may be given within a certain period that the confidence, the release may be
Deposited.
compensated. That is right.
No, it is not deposited, the mort has to revalidate the thing, because it is an additional acquisition.
No, where's the revalidation of anything because of the fact that it's a 3D?
Notification has come.
Then once the 3D has come, then how do you take over?
Now in the Bhumi Rashi portal, the information has to be uploaded, and the process, it will take some time, otherwise it is.
Okay, the petitioner will get the money.
My
Definitely,
lord,
definitely, amount
the
is
entire
No, because we are recording this. I'll give you,
Right,
I'll give you the liberty. If they don't pay within 1 month, you come over.
my lord,
After all, your person is getting good amount, he may
the
again spend
documents
some money
annexed,
on
my
you.
lord,
Yes.
the documents annexed in with this affidavit, my lord, shows the date 2019, my lord.
These are.
All the documents annexed, my lord, in this affidavit, my lord, shows the date in the year of 2019, my lord.
No,
So
no,
to the 2024, so they have given part payment to my for 1 bigger 5 lessons, and they, my lord,
But
till they did not.
Mr. Hussain, now you are going to
Yes,
get
my
the
lord.
money at
Yes,
last.
my lord.
Thanks.
At
The
least, my
client
lord,
should thank you.
my lord.
The instant writ petition has been filed by the petitioner, being agreed by the taking over of the land of the petitioner.
Access land, my lord.
At measuring who is going to pay the money?
Mort will release the amount, PWD will deposit to the Kala will release, Kala will pay the amount.
Understood, but why in December 2023, 8 months back, you have already said that it is under the sanction?
Well, the notification, there some time to, while issuing notification, it was issued in the month of February, in the month of March 2024. Ministry of Road Transport, they have issued the notification, and in that process, the section kindly see 3A and 3G.
We do one
On-
thing,
on
we
3rd of July.
keep, Mr. Hussain, we keep the matter pending. Let us see after 1 month whether they pay or not.
Yes.
Pursuant to the directions passed by this court on 14/8/2024, an affidavit has been filed by the respondent authorities by the respondent number 2, stating inter alia that an area of land measuring 0.1434 hectares, that is 1 bigha 0 katha 7 lecha, situated at village Zarimari, bearing dag number 266, patta number 58, was acquired, for which an amount of rupees 40 lakhs 13,250 was already paid to the petitioner. However, as regards the remaining land of 0.4093 hectares, that is 3 bigha 0 katha 5 lecha, situated at village Zarimali, bearing dag number 266 of periodic patta number 58, for which an amount of rupees 1,14,54,834 have been assessed by the circle officer, Moholdoy Revenue Circle, has been done, and the 3A and 3D notification have already been published. It has also mentioned that the 3G that the procedure mandated in terms with section 3G of the Act of 1956 have already been forwarded to the PWD Rongia NH division, but the same is yet to be uploaded by the implementing agency, that is the executive engineer PWD Rongia NH division. Further to that, it has been mentioned that after that, the process for document verification would be done for generating payment on Bhumi Rashi portal by the office of the respondent number 2. And at the same time, subject to revalidation of the fund for payment by the requiring department, that is MOT, the payment can be made to the petitioner. Also, taking into account the above, this court inquired with the learned counsel appearing on behalf of the PWD NH division
I'm appealing for the.
as to when the petitioner is likely to get his amount in respect to the land, more particularly in view of the notification under section 3D have been already issued, and thereby the land vests upon the central government. The learned counsel appearing on behalf of the learned counsel submitted that the same is likely to take a month's time. Accordingly, list this matter on 30th of September 2024 on an update as to whether the payment have been disbursed to the petitioner.
I'm appealing for the respondent number 2 actually. For the TC also I'm appealing.
NH, PWD, NH.
I'm appealing. Both.
May I plead your lordship? Kindly agenda matter for the day. My senior has some difficulties, therefore he will not appear.
Yes, Mr. Chaudhary, tell me, how did you do this? The amongst the first is okay, the highest is okay, you may give it to higher.
Yes, my
But then how did you limit it only to the first 5?
my lord, that instructions I have received, my lord, may I place it before worship? The worship, the last paragraph of the first page.
As regards the petitioner's
Petitioner
contention
contention
regarding
regarding
proportionality, he has quoted at L1 rate and not L1 plus 15 rate. And there were more than excess requirement for trucks provided by MSU, and as such, the allotment was decided on the basis of seniority as mentioned in the condition. What is this L1 rate and not L1 plus 15 rate means?
In fact, your worship will be clear if your worship comes to the next page.
Yes.
Middle portion, with respect to your query, the following are submitted. As per our system, process of evaluation of transport tender number so and so was done at regional contract sale of LOA. Letters were issued to the successful bidders offering them numbers of TTs against the above contract. It can be said that the RCC follows TNC of the tender while selecting, evaluating the bidders. The TCC final note, that is 2/12/2022 is attached to it, my lord, that I have given, my lord. Kindly refer to the relevant pages. As per TCC note, page 21, bidder Chandra Prasad Bora had qualified as L1 bidder. as per TCC note clause 36, page 24 of that bunch, my lord. Among L1 rate bidders under MSME general NIT TT requirement was 32 numbers. Number of TTs offered was 132. Clause 38A, Roman 1 and 2, page 24-25. TCC recommendation of allocation of TTs are given. Kindly refer point number 2.1 of the average age of TT. It is evident that the age of the TT was considered while finalizing the TTs. Refer serial number 3 MSC general allocation table, page 26-27.
No, I understand that. Then are you saying, means you, means enlist the persons on the basis of the age of the vehicle?
My lord, that if your lordship kindly goes to the chart, my lord, your lordship will find that. Because he was found eligible, then my lord,
Page.
page 27, my lord. Page 27, your lordship will find the name of the petitioner appears at serial number 18.
27.
To 27 of this transfer.
27, no.
The numbers are, my lord, at the bottom.
Huh?
Serial numbers are at the bottom now.
No, page 27 of your affidavit or the what?
No, my lord, in the bunch that I have given, my lord.
Oh, yeah. Yeah, that document is there. I've seen it yesterday.
That particular page has been annexed by my learned friend also.
Yes.
Your lordship will find, my lord, the name of the petitioner at serial number 18. Now, my lord, this has been arranged in accordance with the, my lord, the number of the average age also. And the requirement has been fulfilled by giving it to the, my lord, first 4 or 5.
What is this? I don't understand. Means general is this. Then you have below 12 KL means? Means the
12 kiloliter, my.
okay. 12 to Iman and average age is 316.
Petitioner
Now you had 32.
Yes.
Your requirement was 32, of which you have finished it with 5. Means 5 plus 8, 18, 24, 24 and 32. So amongst the top 5, whoever I have given, you have taken it. And the petitioner was number 20.
Petitioner appears at serial number 18, 18.
3,182 days.
And he had offered, my lord, 18 to 40 kiloliter vehicles. 8 numbers of vehicles in the category 18 to 14 kiloliter. And the provisions under which, my lord, this has been followed, that has been quoted in the, my lord, the email instruction.
Is there stay?
No.
No stay, no? One thing I've understood this. Okay, then we finish it off one day. When? When?
On Mondays.
Monday, this court is so free, there's no work. On 5th. We'll finish it off. Matter having been only a passing of order. It's the matter again on 5th. Now, Mr. M.K. Chaudhary, the learned senior counsel, have placed before this court the reason and have explained to the queries so raised by this court on 14/8/2024. First of all. However, the learned counsel appearing on behalf of the petitioner have sought for an adjournment. First of all. Taking into account that the above this court fixes the matter on 5th of September 2024 at 2 p.m. It is made clear that if the petitioner counsel is not ready to argue on that date, This court shall proceed with the disposal of the restitution.
Well,
Yes. So
So that land acquisition matter, the
Yes.
interpretation of that section and, my lord, whether any, my lord, award existed. Now, my lord,
affidavit,
the deputy commissioner has filed an affidavit the day before, my lord. If your lordship promise, my lord, would like to file a rejoinder.
let me have a look at the affidavit.
Yes,
Why do you spend so much of time filing a reply?
In the affidavit, my lord, they say that there is no award. There was no award. That is the, my lord, sum and substance, but it is not, my lord, para-wise
Well,
reply.
No, what do you say? On what basis you say that there was an award?
My lord, on the basis of the documents that we have also, my lord, annexed in the writ petition, saying that, my lord, we're directed to make payment of the amount.
That has to be directed as per 6.
Yes, my lord.
If we go by the Land Acquisition Act, when it is a case of a company being asking the money, that it has to be first deposited, then only section 6 declaration can be passed.
True, my lord, but at the same time, if your lordship kindly have a look at the documents now, my lord, we say, my lord, that.
Because the award has to be filed before before the collector. In terms with section 12
Yes.
and 1, unless the award is not filed before the collector, nothing is there.
No, my lord, in fact, the collector had prepared the, my lord, the entire, my lord, the calculation, and thereafter it was sent to the, my lord, government for approval. And, my lord, from their own documents, my lord, it is seen that, my lord, approval was granted.
Approval is there, show me. Where is the approval?
Your lordship, my lord, there are several documents I will rely upon.
No, there will be only one document for approval. Herewith an approved copy of the land acquisition estimate amounting to so and so. This cannot be approval.
that is, the approval to the estimate.
That
Yes,
is
my
no.
lord.
Where is
Because
the approval order?
And then your lordship may kindly come to page. What are you doing? My lord, without the approval being made, my lord, we will not be asked to deposit the amount.
See, let's see section 6.
My lord, they say that, my lord, it has been approved. Your lordship also comes to please.
That is why I always say, you see, these state authorities, they therefore go for the Assam Land Acquisition and Requisition Act because of this section 6.
Yes, that
This
is-
section 6, if it is for any other person, they have to deposit that amount. Land Acquisition Act.
My lord, if your lordship kindly comes to page 116.
Kindly come to section 6. Kindly see section 6(1), provided first proviso, second proviso. Provided further that no further such declaration shall be made unless the compensation to be awarded for such property is to be paid by a company or wholly or part out of the public so and so control area by the local authority. Where the compensation to be awarded from such body is to be paid out of the funds of a corporation owned or controlled by the such company shall be deemed to have been compensated paid out of remand. Every declaration so and so shall be conclusive evidence on a year. You are a company,
my lord.
so it will be from 48. Let us see 48. Acquisition for company, industrial concern to be deemed company, previous consent of the execution of the agreement, previous inquiry, agreement with the appropriate company, obligation of the agreement, section 4 year not to apply to companies where government bound by an agreement to provide land for the company or agreement transfer to be acquired under penalty. Possession is given to you.
Yes, my lord. Possession was taken a long time back, my lord. Possession handed over is 64. In my lord, 27th of November 2000.
2000.
Page 64, my lord.
Possession was taken. So, and
then,
you
my
paid
lord,
the money before that.
My lord, the surface compensation was paid. That at that time, my lord, the land acquisition proceeding was not initiated.
Then,
But my lord, the surface compensation was directed to be paid. We have paid the surface compensation. Then we had insisted that land acquisition proceeding has to be started. Then the petitioners also, my lord, the landowner also filed a petition that land acquisition proceeding has to be started. Then my lord, this honorable court directed that the proceeding has to be started. Both the requisitions were disposed of jointly.
where? Land shown in the below identified base and schedule there, handing over. Land has been taken over on 27/11/2000. And there is an order whereas land acquisition has been initiated for acquiring the area currently under the possession as per the honorable court's order. This was done on 3rd of May. Now,
Yes, 3rd of May.
the terms and conditions of the order is that the rate of rupees per bigha for the land of urban area, the rate was approved by so and so. Now, what is this order?
11th of May, my lord.
3rd of May.
3rd of May, page 91.
Yes, what is that?
Before that, may I implore your worship to see my lord, page 116.
116. Yes.
This is a communication from the deputy commissioner. Now, my lord, this is an order passed by the deputy commissioner. Second paragraph, your worship will kindly read. Whereas both the parties have submitted their respective written statement in support of their claim and objection in regard to the value of the land as determined in the LA case number so and so, and examining the case records of the land acquisition case number so and so, the Oil India Limited has not deposited the award amount. So it is according to them also, my lord, it's an award amount till date. So without there being an award, my lord, this order would not have been passed.
But where is the award?
My lord, what happens, my lord, in land acquisition, they do not serve us the, my lord, award itself. But my lord, they send the demand notice and we.
No. Award has to be filed before the year. Section 12, let us see.
Because it's 108 is the.
Then that is the date on which the limitation will start. 11A, the collector shall make an award under section 11A. And the 11 within a period of 2 years from the date of publication of the declaration. And if no award is made within that period, the entire proceedings for acquisition of the land shall lapse. So that is one. The court's order directing acquisition or not would not help you. It will go. These are mandatory. Award when final. Such award shall be final in the collector's office and shall, except as hereinafter provided, be final and conclusive as between the collector and persons interested, whether they have respectively appeared before the collector or not, of the true so and so. The collector shall immediately notice of demand shall be filed in the collector's office. So this award has to be filed in the collector's office, then it would be final.
Yes, my lord, that,
And this has to be preceded by the approval. Can you see 11?
yes, my lord.
11, the proviso. Provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or such officer as the appropriate government may authorize in their behalf. Provided further that it shall be competent for the appropriate government to direct the collector make such award without any approval in such class of cases that the government may specify in that behalf. That second does not come, first will come. Where is the approval?
No, my lord, that, what I am submitting is that, my lord, that is never communicated to us. In other land acquisition cases also, but the, my lord, demand is made. If your lordship kindly comes to page 108, they have made the demand.
They may make a demand to you, but that doesn't mean that the acquisition has happened. And what will happen now? As of now,
As of now, my lord,
it will lapse.
no, my lord, it has not lapsed.
Yes.
The award, award was.
If there is no award, it lapse.
No, now the question is, my lord, your lordship has to, on the basis of these documents, has to, my lord, satisfy your lordship that, my lord, there was an award, although, my lord.
No. First and foremost, board notification comes within 1 year, you have to come with a section 6. 6 comes, you have within 2 years, you have to come up with an award.
Yes.
How do you take care of that situation?
My lord, this.
That is the mandate of law.
Section 6 notice was issued, my lord, on 17/9/2011.
So if there is no award till date,
No, my lord, what we see is that, my lord, from these documents itself, my lord, in 2011 itself, my lord, there was an award.
where?
That is what, my lord, these documents, my lord, reflect.
With
Otherwise,
reference, I would like to inform you that the sum of so and so only against LA case number so and so was fixed as per the High Court's order para judgment whereby a meeting was convened in so and so. The value of the lien was fixed per valuation report dated so and so. Additional compensation is there. Therefore, you are requested to deposit the aforesaid amount under the fees under so and so. This is normally done when section 6 is issued. Even prior to section 6, this is done. When was this? When was section 6 issued?
17/9.
2011. So the moment there is, because now the question will arise for payment. What is the award? No award.
Because, my lord, what we are trying to implore your lordship is that on the basis of the, my lord, these communications, it was, my lord, it has to be, my lord, come to a logical conclusion. The award was passed. If your lordship comes to page 97.
Unless it is filed in the office. Approval has to be there.
The estimate was sent for approval.
It's a different thing. The state may not have done it. I'm not concerned with that. But her right goes now.
Lord, the well, High Court has been informed by them that, my lord, the approved copy has been, my lord, has been sent at page 97.
Everything the state government does, they do whatever may be. May pull many people into a lot of problems. That is a different thing, but that cannot take away her rights under 300A.
My lord, question here is of, my lord, huge.
I think return the land.
Public money involved, my lord.
Return the land. There is no award. As of now, there is no award.
Have already.
Award whatever have passed in view of the mandate of section 11A, it has lapsed. How do you take care of 11A? Because the Supreme Court categorically says that the infraction to section 6 Then 11A and 4 goes. Acquisition proceedings can be challenged only on these three, 4, 6, 1 and 6, 1, the court say, the Supreme Court said that the as regards the notice, the publication is not necessary, the declaration, the moment it is made, then it is itself. It has been said to be covered this within 2 years, it has 1 year, it has to be done, it will cover that.
My lord,
But here the award has to be passed within 2 years, not done.
my lord, we have taken possession. We have also, my lord, paid about 10 crores of rupees in the meantime. So, my lord, the question here that will fall for consideration of your lordship in, my lord, whether it will lapse by virtue of the, my lord, section 24. That has to be.
We'll convert it into requisition expenses. The 10 crores. Remaining paid land compensation.
In fact, my lord, that is 2011. Then, my lord, in 2017 also, my lord, they have passed orders. That also reflects, my lord, there is an award.
Therefore, they are saying 24-2. This is prior to indoor.
Yes, this is.
This is prior to, have
Prior to
not
indoor.
received any amount and hence as per had not deposited the amount of so and so, hence it is decided that since Raya had not deposited the award amount as per section 11, hence the proceeding drawn under the provisions, the same is deserved to have lapsed. This is prior to indoor. In view of the above, further proceedings of lawyer should be carried out as per the provisions of Iman. Let the parties decide. This is wrong. They could not now do it, although payment not made, but the payment being deposited in the treasury would amount to that. But where is the award? Yes, what is the affidavit?
But, paragraph, I'll take your lordship. to
Where is the
paragraph.
affidavit?
So we filed the affidavit on 29.
You like to file reply? But you don't get. Huh?
On 29th, we have.
Day before, they have served, okay, day before yesterday.
They were not filing. On that day, I had to be a bit strict. Then only they filed.
Some records are.
Yeah.
Kindly see para 7, 8 and 9 for the time. Para 7, 8 and 9.
And especially the declaration as per section Iman dated so and so was published. That in pursuant to the common judgment and order dated Iman and the direction Iman, a meeting was convened in so and so. Pursuant to that, no compensation was deposited. Instead, they had prepared a writ petition challenging the said. Another writ petition was prepared by the lawyer for payment of compensation, which was demanded. Okay, so I'm bringing the proceedings to a conclusion and arrived at an appropriate determination of the complaint down other directed so and so. Once with the one when the follow-up was made. No, we carried out this protocol.
So they are talking about that, this letter, 16/7/2011 letter that we have asked for.
Huh?
Well, the petitioner is referring to this letter dated 16/7/2011. We have mentioned in paragraph 8 last line that the Oil India Limited was requested to deposit the amount. That letter, paragraph kindly para 9, that letter was challenged in another writ petition. And in that writ petition, order.
Was there a stay to the LA proceedings? Any stay at any point of time?
In WPC number 5372 of 2013, Honorable Court passed an order on 8/2/2017 at NHF 4 lodgeable file.
NHF 4.
NHF 4.
What is that?
The
Page
Honorable
52? NHF 5372.
of 5372.
What is that order?
Their lordship has directed us to pass an appropriate order.
No, was there a stay? Was there a stay to the LA proceedings? No.
Not to the LA proceeding, my lord.
But
If there was no stay, how do you take care of 11A? 24(2) may not apply in view of indoor, but how do you take care of 11A?
My lord,
If the award is not passed within 2 years?
but
You came up with a section 6 on in the year 2011.
79
Till 2013, you had the time to give the pass the award. If the award is not there, how do you take care of 11A?
Well, but our specific stand is that there is no award.
Hmm?
There is no award. Award was not passed.
Where the records?
I have.
Last time matter, Mr. Rishikesh Sharma was telling me that the records are very big. Let's see how big it is.
I have 3 files.
Problem arises there. And you see, Mr. Chaudhary, another huge big problem. The manner in which the district administration are taking up these acquisition matters, and the manner in which the reference are being delayed, it really affects the state. That is why in all my orders, I give a very specific order. Within 15 days, you have to do. Otherwise, what will happen to the interest?
Yes.
Because it is a huge thing.
This is the third file. Other 2 files.
Year of 2023, and no awards under LA as per section Iman on or before Iman. After that also, have you passed? No.
Well, in our affidavit in detail, we have.
Here you see, hence an award has been passed in LA case number 192 or after 1/4/2014. Where?
Now,
When did you pass that? Where is the award?
well, kindly come to para 17 of our affidavit.
File is big because of your petition, otherwise file is small. Where is the award? Notification, rules for fair. Where is the award? Hmm. 19 September, I am forward the manuscript of the declaration. Submission to the High Court, existence of a LA ward of so and so, the LA ward number so and so was approved by the Deputy Secretary dated so and so. According, DC requested all to deposit. Now, this is a very important aspect. Where is this come from?
Paragraph
The
17.
LA award for 5,90,094 in LA case number 192 was approved by the Deputy Secretary, DRM Revenue, by letter dated so and so dated 29/10/2011. Accordingly, DC Tinsukia requested oil to deposit the LA awarded amount. The LA award for rupees so and so in LA was approved by so there is the approval on 29/10 and 13/10 of 2011. Then why haven't you paid? Why didn't you pass the award? Yes, that is why there is no reply in that aspect. Why didn't you pass the award?
But in fact, well, that particular letter, it is as regard the approval of the estimate.
Huh?
It was as regard the approval of the estimate. Although it is
No,
written
no, this is an approved. This 29/10
29/10,
DC requested oil to deposit the LA awarded amount. Thereafter, where is this document? Hmm?
in the writ petition they have annexed.
We have annexed that at page 97, 110, 101.
And acquisition officer.
Page that-
Yes, here the award comes. This is the latest award.
This
Latest
is-
award is how much?
That it is, my lord,
20 crores.
20 crore. 20 crore, 89 lakhs, 67,500.
Okay, cost of establishment. Okay, this is the latest award. But how do you pass the latest award? And where is your approval then? Prior to passing this?
So that's
Resident so and so, this is submission. How do you pass the award now? In 2023, how do you pass the award? What is the
After
date
the-
of this award? Huh? Award has no date. God will only save you. Hello. 5 o'clock on a Saturday.
And my lord, there is black cloud, my lord, everyone is fearing about rain.
No, but Mr. Chaudhary, have a look at this document. Huh? This is a very important. This will be give you some breather to your case. Well,
I would have, my lord, prayed before lordship to allow me to go through the matter report.
so see this document. This is a very important document. Anyways, the Hawk matter having been heard at heard at length, the matter be again listed on when?
My lord, 1 week time we will grant.
Yes,
it, like-
see that document.
Yes, my lord, 166.
This is a very important thing.
Say DLA award amount 5 so.
So the approval has already been given. And you are the deputy commissioner was asked to do that. The deputy commissioner did not do it. He can't do that. The deputy commissioner has to be put to task. But how to do you deal with that? Because the collector has done this. It is the collector who has to file it. How do you take care of that? Award has been approved, seems to be. That document is the most important document. The approval is there.
so
You
that-
see, what happens, the award is being made, then they send it to the department, and the department thereafter approves it, and then it is being filed. So, there is no separate order required by the deputy commissioner.
That particular format.
Whether that is filed in the records is the thing, because you see section 12(1) has to be filed. So, when you make the award, you send it, approve, you file it. And that becomes the conclusive evidence. So if it is filed on that date, the records therefore has to be seen as to whether after that what has happened. The records will show. So there your answer is there. Otherwise too, if we go by that new one, the proceedings have lapsed in view of 11A. Okay.
Everything changed when the new deputy commissioner joins.
Huh?
Everything changed, my lord, when the new deputy commissioner joins.
No, that may be, but no. The question is, did he file it? He doesn't need to pass an order.
Yes, it has to be on the record, it has to be filed.
Whether it is filed. Matter, if it is filed, the matter ends. Please.
Award is pursuant to a DC, what they call award is 3/5/2011. That's the date that's important. The notification section 4 is 25/11. So all of this happens before section 4 notification.
No. This is 22/12.
Yes, Your Lordship. The amount is in a DC meeting, tripartite meeting, pending zonal.
No, this document, the award was sent to the Deputy Secretary Revenue has approved the award on 29/10/2011.
But it's an interim payment. Lordship, when my turn comes, I'll show you. There's a tripartite meeting before section 4. they say pending zonal valuation final, we'll come into an interim estimate. We come to an interim estimate, and this is all before section 4, which is why there are three.
No, when was the section 6 given?
1779.
2011.
So this is after that, 2910.
Lordship, if at all, it is what the Lordship says. is
We
section
are
six.
to find out this document and as to whether it is filed. Matter ends there.
Then they challenged it.
I can't help you. Then division bench is to help you. After if I find that, then nothing more. Today I don't have the time and the clouds are hovering. Yeah. Okay. Heard Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner. Senior counsel appearing on behalf of the petitioner, and Mr. D. Nath, the learned counsel appearing on behalf of the respondent state, and Ms. G. Goswami appears on behalf of the private respondent. The matter upon being heard and the records being produced, this court fixes this matter again on 12th of September.
A week after that,
Okay.
after 16.
19th.
Yes.
19th of September.
The ground liberty to file.
The petitioner would be at liberty to file their reply. But you see that record and first of the council, this court further grants the counsel of the petitioner with due intimation to Mr. D. Nath to peruse the records.
I'm grateful.
Full stop.
Our land is gone.
You are always with him. They are helping you out.
Whatever is available in the record.
No.
I have seen. I have put this before you.
The parties herein are given the liberty to approach Mr. D. Nath for perusal of the records. And this court would request Mr. D. Nath to oblige to us.
They will take any other date, my lord, except 19th, my lord. Too many matters
Okay.
fixed. Too many matters fixed, my lord.
Okay, no problem. We'll have it on 20. And then no time. We are having it on 22nd of October.
Oblige.
For 123.
It will have been heard at length of Gusaripuri. So and so, heard so and so, learned counsel, yeah. An affidavit has been filed by the respondent state. Mr. M.K. Chaudhary, the learned senior counsel, submits that he would like to peruse he would file an affidavit in reply. List the matter again on 23rd of October 2024. The affidavit may be, in the meantime, the reply be filed.
Let it be 19th.
No.